started.
Morning, Your Honor.
I believe we'll begin with the Spanish interpreter cases.
Actually, no, we can do them as we go. I'm just gonna swear her in,
Okay.
that way she's sworn in, and then we need all the attorneys to announce themselves on the record.
All right, Madam Interpreter,
Yes, Your Honor. Good morning.
good morning.
Can you raise your right hand, please?
Yes,
Do
ma'am.
you solemnly swear to translate from Spanish to English, from English to Spanish, the whole truth and nothing but the truth, to the best of your ability?
I do. Astrid Rodriguez, certified Spanish interpreter.
Thank you.
All right, and appearances there in the courtroom?
Your Honor, Dania Simpkins on behalf of the state of Florida.
That's not right. Yeah, he's bonded out. But this is Silva.
And have, he must have claimed it.
Appearances there in the
Your Honor,
courtroom in Osceola? I'm taking appearances of
I'm
counsel.
sorry, Your Honor. Yes, Your Honor. Yassine Amba on behalf of the PD's office.
Can you spell your last name for me?
Yes, A-M-B-A, Amba.
Thank you very much. Any others?
Joy Gibson, PTR.
Thank you, Ms. Gibson. All right, the first case is Alexandra Augusto.
Your Honor, she qualifies. She does want the appointment of the PD's office.
All right. Hello, Ms. Augusto. You're here on charges of possession of a controlled substance and possession of drug paraphernalia. Court's found probable cause and appoints the public defender to represent you. Does the state wish to be heard?
Your Honor, the state would request that the court leave bond as is.
Defense?
Yes, Your Honor. We're in agreement with the state.
All right, court will stay bond at $1,000 on the possession of a controlled substance charge and $500 on the possession of drug paraphernalia charge. Thank you. Anything further?
No, Your Honor.
All right. Next case is Andy Arroyo.
Your Honor, he's in detox, so we could reset this for tomorrow.
All right, case will be reset for tomorrow. Next case is Julio Ibar.
Your Honor, he's
He bonded.
bonded out already.
Amanda Baldwin.
He's bonded out, Your Honor.
Yes, I heard. Next case is Amanda Baldwin. All right, good morning, Ms. Baldwin. We are here on a charge of driving under the influence. The court will, let's see, it looks as though, does she qualify for appointment of the public defender?
She does, Your Honor. She does want an appointment.
All right, court will appoint the public defender. I've reviewed the arrest affidavit and find probable cause for the charges alleged. State wish to be heard?
Yes, Your Honor, state requests bond be left as is. I also have Ms. Baldwin for battery. Are we also addressing that?
I did not see the second case.
It's a separate case.
Court finds probable cause for the battery. Defense wish to be heard as to bond.
No, Your Honor.
Court sets bond at $500 on the charge of battery and $500 on the charge of driving under the influence. Thank
Your
you.
Honor, the state would also request no contact with the victim on the battery.
Where does Ms. Baldwin reside? Is she
I live with the victim, but I do not intend on going. I have the no contact order, so I'm going to go to a different family member's home.
All right, you have somewhere to go, though?
Yes, sir.
Okay. No contact with the victim.
Yes, sir.
Thank you.
Yes, sir.
Does he qualify?
Chester Bell, Mr. Bell?
Yes, sir. Good
Right.
morning, Your Honor.
Good morning. You're here on a single charge of battery. You have.
Your Honor, he wants the appointment at the BD's office.
All right, good. The court will appoint the public defender's office. Court finds probable cause. Anyone wish to be heard as to bond?
Yes, Your Honor. The allegations are that he took the glasses off his girlfriend's face. She did not want to prosecute. She actually walked away from the cops when they tried to talk to her. She still doesn't want to prosecute. Given those facts, Your Honor, we ask that he be released on ROR.
Your Honor, the
Any
state...
opposition?
I'm sorry?
Any opposition?
Yes, Your Honor, the state would be requesting a bond, would also request a no hostile contact order. It appears that a no contact order might be excessive, but no hostile contact would ensure that the incident is not repeated and the protection of the victim.
All right, court will ROR Mr. Bell.
Okay.
Thank you.
Thank you so much, Your Honor. Thank you so much.
I'm going to order that.
Oh, it's Karen, the one that...
John Blagg?
You guys are allowed to ROR.
You call a case, Your Honor?
I did. John Blagg?
Yes, Your Honor, good morning.
Good
Yes, sir,
morning.
Good morning, Your Honor.
All right. Mr. Blagg, you are here on a warrant for failure to appear on an underlying charge of misuse of 911 calls. Do you wish the public defender to be appointed for you?
As far as I know, Mary Jane Cooper's already been assigned to the case, sir.
All right.
He does, Your Honor.
All right. Public defender is appointed. Judge Epperson set the bond at $500. Does anyone wish to be heard?
Your Honor, since it's...
Yes, Your Honor. He's
Defense can go.
informed me that...
You can go.
He's informed me that he was not aware of the court date, and that's why I missed the court date. He said he'll make all future court dates, and he's gonna have some trouble posting the $500 bond. Either release him on PTR or ROR.
And
I did turn myself in on this morning, Your Honor. You know, I have no problem at all seeing you, and I know the case is kind of minor, and I apologize for just jumping the gun with this. But I was released on ROR at about 7 or 8 o'clock in the evening, and I wasn't given any paperwork, and as far as I know, they ROR'd me because the state had not filed charges. But I have absolutely no problem showing you, you know, my honesty in coming to court. It's a very minor case. I have no problem following through. If you do the PTR, I would appreciate it, sir.
And Your Honor, because it's a
And
failure...
I did turn my,
Just 1 second,
but
sir.
I did call, okay.
State.
Your Honor, because it's a failure to appear warrant, it's the state's belief that because of the cases cited to the court yesterday by the state, the court has to leave the amount of the bond as set.
Yeah, I don't know that I can do anything with respect to the bond, so the bond will stay as set by Judge Epperson at $500. Thank you, sir.
She don't...
That's her.
Castillo Abraham.
Your Honor, we'll call her at the end.
All
She
right.
can stand up. No, just leave her in the cage.
I'm putting her at the end of the docket.
Guess she's,
Yeah, we're gonna call it the end.
Next case is Lawrence McDougal.
That's not it.
Did Heitzman bond, Judge?
Heisman is after McDowell, McDougal.
Heitzman's after McDougal. Hello, Mr. McDougal. You were here on charges of providing false identification to a law enforcement officer and possession of drug paraphernalia. Do you wish for the PD to appoint you in this matter?
Yes, Your Honor.
All right, public defender will be appointed for Mr. McDougal. Court's reviewed the arrest affidavit and finds probable cause for the charges alleged. Any party wish to be heard with respect to bond?
Yes, Your Honor. Regarding the first count, possession of cocaine, we asked that it be reduced from $2,500 to $1,000. I think $2,500 for possession of cocaine is a bit excessive.
I think we're looking at different
Oh,
cases.
Your Honor, actually, yes, I'm looking at the one above him. $500 is fine with the defense.
Your Honor, I believe there may be bonds of 500 on each charge, is that correct?
Yes, the court will set bond at 500 on the false identification charge and $150 on the drug equipment possession charge. Combined bond of 650. Thank you. Dakota Heitzman?
He does. He does.
How you doing, Honor?
Good morning. Mr. Heitzman, you are here for a first appearance on charges of possession of cocaine and possession of drug paraphernalia. Court. Are you requesting the public defender to represent you in this matter?
Yes, sir.
Public defender will represent you. Court finds probable cause for the charges alleged. Does anyone wish to be heard as to bond?
Yes, Your Honor, he qualifies for PTR, direct PTR, and he does want to be released on PTR.
Any objection to PTR?
Your Honor, I don't have the defendant's criminal history with me. This is Mr. Heitzman, correct?
It is.
Yeah. The state would recommend a bond of $500 on the possession of cocaine and ROR on the paraphernalia.
You want that inside?
Yeah.
I don't.
I'll deal with it.
All right, PTR.
Okay. Corrections, any input as to PTR? Any issues? Oh, Osceola. Any issues with respect to PTR?
Your Honor, he only has one paraphernalia back in 2017.
All right, court will order trial release. No controlled substance use while on pretrial release. Thank you.
Thank you, Honor.
Michael Perez,
Your Honor, we could call him at the end as well.
all right. Miller Silva Rodriguez.
He'll require the use of a Spanish interpreter, Your Honor.
Okay. Good morning, sir. You are here for a first appearance on a warrant.
Buenos días, señor. Usted está aquí hoy día para una comparecencia inicial a través de una orden de arresto
Related to a failure to appear on an underlying charge of driving with a suspended license.
pues por fallar en comparecer en un caso original de manejar con la licencia suspendida.
Do you wish for the public defender to represent you in this matter?
¿Usted desea
Your
que
Honor,
se
I
le
believe this is
asigne
an
el defensor
out-of-county.
público para...
What is the county?
Sí.
Un momento.
Yeah.
All right. Then the court will not appoint a public defender. Bond has been set in the warrant at $2,000.
No voy a fijarle un defensor público porque es de otro condado. La fianza está fijada ya en $2,000.
And the court will stay the $2,000 bond on the failure to appear on the driving with a suspended license charge.
Y la fianza permanecerá en $2,000 esto por fallar en comparecer en la acusación de manejar con la licencia suspendida.
Mr. Silva Rodriguez, that means your bond is set at $2,000.
Señor Silva Rodríguez, eso significa que su fianza permanecerá en $2,000.
Thank you.
Gracias.
He won't say something.
Or is bonded out. Or is bonded out. Or is
All right.
bonded out.
Yadiel Torres.
Your Honor, she's bonded out. Oh. My bad. Good. I apologize, Your Honor. He's here. It's all messed up.
Hello, sir. You are here for a first appearance on charges related to petty theft, obstructing justice without violence, and burglary of an automobile. Do you wish for the public defender to represent you in this matter?
Yes, sir.
Public defender is appointed to represent Mr. Torres. Court finds probable cause
Anyone
for the
have been
charges
forward?
alleged. He meets the requirements for PTR.
Yes.
State?
Your Honor, state would request that the bond remain as is.
Defense?
Your Honor, he does qualify for PTR, and he would prefer to be released on PTR.
All right, court will order release on PTR.
Thank you, sir.
Thank you. Georgie Vargas Cruz.
Mr. Cruz has bonded out.
Luis Anabel Ramirez Lamort. This is a reset from
Mr. Lamont
yesterday.
is, he's still in detox, would have to reset again.
All right, reset for tomorrow. Carlos Manuel Santana Brito.
He's also in detox, Your Honor, he'd have to be reset.
He will be reset for tomorrow.
Karen.
Nico Kalel Vega Fuentes. Hello, Mr. Vega Fuentes.
How you doing, Your Honor?
You are here on a violation of probation related to an underlying charge of possession of methamphetamine, as well as, I have in my notes a new charge. Is that inaccurate? A new offense of petty theft?
I don't have anything on my side showing petty theft, Your Honor.
Wonder where I got that.
Judge V.O.P.
I don't have petty theft on my paperwork, Judge, but the violation was failure to live without violating any new laws. So that may be a new law offense that's just not listed.
All right. All right, Mr. Vega Fuentes, I don't think I appointed the public defender. Do you wish for the public defender to represent you?
Yes.
All right, public
Yes, sir.
defender will be appointed. Court finds probable cause for the violation of probation. Yes. State have any input?
Yeah, as a VOP warrant judge, the state is of the impression that it must be stayed at whatever the bond is currently set at, which I believe is $0.
Defense?
That's correct, Your Honor.
All right, bond will be stayed at 0.
What's he making all that damn noise?
Mr. Amba, did you want to call Castillo Abraham or Michael Perez? I have no
We
preference.
could call Castillo Abraham at this time. And she does want the appointment at the PD's office, and we ask that,
Good afternoon, Your Honor.
Good afternoon. Court will appoint the PD. Ma'am, you're here on charges related to domestic battery violence. Court finds probable cause. Are there any witnesses there? I guess they'd be here. I'm sorry,
No one here,
witnesses.
Your Honor.
I meant victims.
There's witness,
We were unable to contact the victim, Your Honor.
Okay. I understand the defendant and the victim to reside together?
no, she comes to my mother's house and disturbs upon our peace. She's not a home. She's not the home residence or anything. She has her own house.
Okay. State wish to be heard as to bond?
Yes, Your Honor. Regardless of the court's decision as to the bond amount, the state would request there be no contact, maintain separate residences.
At the moment, right now, I don't seem to be actually well protected. I need a witness protection program. She has stolen properties and stuff like that. I don't want to be in the household, please. Maybe so, yes.
Your Honor, we ask that Your Honor either release her on ROR or set bond of $500.
Wait, I just want to understand, okay. Where does Anna live?
She doesn't live with
Her mother?
Anna,
They were both attacked.
who's
at the same
Anna?
time.
And he's asking, where does Anna live?
178 Seabury Circle.
Where do you
She does not
live?
live with her.
Where do you live, ma'am?
On 178 Seabury Circle. Sir, can I please clarify the right correction name of the victim? That was, I guess,
If you can talk to your lawyer, that would be my question to him, is who's the victim here?
both of them were attacking me at the same time. And then they stole properties, in which I have to return to someone. I was being attacked, and I said, please get off me, please get off me. I want to go visit somebody.
Your Honor,
So I think your
According
client, I
to
think your
Ms.
client counsel was suggesting that Rosa was involved in the altercation with Karen. I think the arrest affidavit suggests Karen was in the altercation with Anna, and it appears Karen and Anna live in the same residence, so that's what I'm struggling with.
Yes.
that is correct. According to Ms. Castillo, it seems like the other two were in altercation together, and she was involved as well, but they all reside at that address.
And not Rosa Sorop. Her name is Rosa Maria Sorop Abraham. The affidavits actually show wrong legal names. I don't know if that's the correct name on which the KPD was told from Rosa. I don't know if he didn't show any type of identification, only a verbal matter, and he was the one that actually wrote the statement affidavits.
All right, does your client have somewhere to go, counselor?
I actually have witnesses that have seen the act on which occurred. I do. My park place, social worker, she actually has a place nearby, I don't want to say location here, for witness protection program of my risk and education and stuff.
Okay, so you don't want to go, your client does not want to go back to the residence that she formerly shared with Anna?
No, sir. I felt threatened every single time, either verbally abused or physically abused or false accusation of being threatened by being arrested for false accusation of charges. It's
Okay.
nonstop.
Good. I think then the solution is
It have
probably...
caused many jobs. It have caused actually one of my
Okay, ma'am.
best jobs and career.
Ma'am, just give me a moment.
diploma.
The court will set bond at $500 on the battery claim. Order the conditions that Ms. Castillo Abraham maintain a separate residence from Karen and Anna, no contact. And to the degree Ms. Castillo Abraham needs to return to 178 Seabreeze to retrieve any personal belongings, it'll be while accompanied by a law enforcement officer.
And Judge, the state requests that the no contact be both for Anna Abraham and for Rosa Maria Abraham.
I thought it was, but if I didn't say that, yes, it is.
It is.
All right, thank you. Anything further?
That would be perfect, sir. Thank you. What about actually my book bag in which she obtained? And
That
she beat me for that.
that won't be addressed today,
Okay, no,
but your lawyer can
anything's
advise
going
you.
about that? Have a great day, sir.
All right, court's recalling Michael Perez.
Yes, Your Honor, he's on his way. Your Honor, he does qualify for the appointment of the PD's office. He does want us appointed. And we just ask on count one that possession of controlled substance without prescription, the bond amount be reduced from $2,500 to $500.
And no objection from the state judge.
All right, good afternoon, Mr. Perez. You're here for a first appearance on charges related to possession of methamphetamine and possession of drug paraphernalia. Court will appoint the public defender to represent you. Court finds probable cause for the charges alleged and will set bond on the methamphetamine possession charge at $500 and the paraphernalia charge at $150. Thank you very much.
Thank you, Your Honor. Have a good rest of your weekend.
You too. All right, the first case is Carlos Martinez Benitez, 2020 CF 2133. If you'll make your appearance, Counselor.
Jeanette Castillo with PD's office.
Thank
And
you.
again, Judge Dane Simpkins with the state of Florida.
Yeah, she's signed in from downtown. She's on the line. She's listening.
Good afternoon, sir. You're Carlos Martinez Benitez?
Yeah.
Right. We're here on a first appearance related to charges of aggravated battery with a deadly weapon and false imprisonment. You have the right to counsel. Do you wish for the court to appoint the public defender for you?
No.
No? All right.
No.
You have the right to remain silent. Anything you say may be used against you. The court finds probable cause based on the arrest affidavit for the charges alleged. And does the state have any input with respect to bond?
Yes, Your Honor. The state would note that the facts of the case are similar almost to an attempted rape. There is indication that the attack with a machete or sword started once the victim declined to have sex with the defendant, who then, after attacking her with the sword, grabbed her and wouldn't let her go. Considering the facts of the case, the state would recommend that this court impose a bond of $5,000 on the aggravated battery with a deadly weapon and a reasonable bond on the false imprisonment as well.
Mr. Martinez Benitez, is there anything you want the court to consider in determining the appropriate bond to set in your case?
Pero es que yo no he hecho nada de eso.
I didn't do any of those things.
All right. Court will stay the bond in the amount of $3,500 as to the aggravated battery charge, as well as to the $150 for the false imprisonment charge. Thank you, sir.
It's a city ordinance. It's a city ordinance case. It's originally there. Were any other things yours? No. Okay. So today is just the day to find out if you're gonna be released on bond. We will probably get an offer to resolve the case today. If you wanna resolve it, you can. If not, then, we'd see if we can get you released. Right now, the bond is $250.
All right, good afternoon, sir. Are you Homero Robles?
Yes, sir.
Okay, do you need interpretation?
No, sir.
Okay, great. You're here for a first appearance related to a claim of prohibited camping. Do you wish for the public defender to represent you in this matter?
Yes, ma'am. Yes, sir.
Court appoints the public defender and finds probable cause for the charge alleged. There's an underlying ROR for petty theft.
Your Honor, if I may, I actually represent Mr. Robles in that petty theft charge. At this time, if we were asking that the court take no action and release him on ROR as to the camping.
State.
Your Honor, presuming that the defendant does not want to resolve his camping charge today, the state would recommend that the court ROR the defendant as to the camping charge, but revoke the ROR as to the other charge as he was released prior to committing this offense.
Your Honor, the offenses are not related in any way, shape, or form. One's a misdemeanor, the other one's a city ordinance case. He actually has arraignments coming up, and if we can verify contact today, there shouldn't be any issue with getting him back to court.
Does he want to resolve? He doesn't want to resolve the camping charge?
This one here?
The camping charge that I just asked you about? He wants to hear an offer now.
All right. State.
Your Honor, state's offer would be adjudication court cost time served.
All right.
All right. You understand the terms of the plea that's been offered to you by the state?
Yes, sir.
And you understand the rights you're giving up by opting to take that plea?
Yes, sir.
And you do so of your own free will?
Yes, sir.
All right. Court will accept the plea based on Mr. Robles' testimony. It was for adjudication withheld, right?
Adjudication of guilt, Judge.
Adjudication of guilt. Adjudication of guilt, credit for time served, and award of costs.
No contest.
Your Honor, he's entering a plea of no contest.
No contest? Any objection?
No.
Court takes no action on the underlying petty theft claim.
And how many days time served, Judge?
Yes, on petty theft.
Within a year. Court cost within a year, counsel.
Sorry, Your Honor, were you talking?
Court cost within a year.
Yes, please.
I'm sorry, sir.
All right, nothing
So
further?
the next court date is March 11th. And I am the attorney on that for now, so make sure you show up.
I'm not sure. I won't be. So they didn't invoke the bond?
Correct.
Okay, that's good.
That's it.
Okay.
Thank you,
Your
sir.
Honor.
Good luck. Hector Luis Roman Diaz. All right, Mr. Roman Diaz, you are here for a first appearance on charges related to an open container and prohibited camping. Do you wish the public defender to represent you in this case? He does, and the public
Yes.
defender is appointed. Court finds probable cause for the offenses alleged state?
Your Honor, if the defendant wishes to resolve his case today, the state would offer an adjudication of guilt, court costs, and time served on both. If he does not want to resolve his charges today, the state would recommend staying the bond as is.
Your Honor, defense would ask that we waive court costs on one count.
Yes, Judge.
Why is that?
Because it's the same offense.
Oh, I see what you
and
mean. Okay.
Yeah,
He's going to be
it's-
paying
it's-
double for the same plea. It's not unusual for us to do that.
Yeah. And no
Does
objection
he
to
wish
that.
to do that?
I'm sorry?
Does he wish to accept the plea?
Trying to find out right now.
Sí.
¿Usted entiende la oferta? ¿Entendió la oferta?
Ok, ya estoy cumplido.
Ok. Entonces, si me puede llevar firmar aquí abajo.
Also a plea of no contest?
Yes.
All right, Mr. Roman Diaz, you understand the terms of the agreement that you've entered into? You understand the terms of the plea that you've signed here? Okay. And you understand the rights you're giving up by entering into that plea?
Sí, señor.
All right, the court accepts the plea.
Yes.
Court accepts the plea, adjudicates Mr. Roman Diaz guilty with credit for time served and costs as to the single count, and the time served is to have run concurrently.
And the amount of time served, Judge?
2 days.
Thank you.
Thank you very much.
Gracias.
Thank you.
Benjamin Venegas.
Sí.
Afternoon, sir. You are here for a first appearance on a charge of prohibited camping. Would you like the public defender to represent you in this matter?
Repítamelo de vuelta, no le escuché.
He's asking for a repetition. He says he does not hear.
Oh.
Could we see if his headset needs to be turned up a little bit?
No entiendo.
It has a,
¿Usted escucha bien los audífonos?
Sí,
Ok. ¿Lo puedo oír bien?
sí, traduzcan.
Can you hear me, sir?
Yes, sí.
All right. You would like
Yeah.
for the public defender to represent you in this matter?
No, señor.
No?
no, sir.
All right. Court will not appoint the public defender, finds probable cause for the offense alleged. Does the state have any input?
Yes, Your Honor. If the defendant wishes to resolve his case today, the state would recommend a withhold of adjudication, court costs, and any time served. Besides that, Judge, the state leaves bond amount in your discretion.
Me declaro culpable.
Sir, do you
I
understand?
plead guilty.
All right. Court adjudicates Mr. Venegas guilty, gives him credit for time served, awards court costs, cost to be paid in 360 days.
Sí.
All right, thank you, sir.
Yes.
That's all. Is this Raul Davila Nieves?
Yes, sir.
All right. All right, do you need the headphones?
No.
Okay. You're here on a first appearance related to a count for violation of a domestic injunction. as well as an underlying claim, I believe, of driving with the license suspended, revoked rather, as a habitual offender. You have the right to remain silent. You have the right to counsel. Would you like the public defender to be appointed to represent your interest in this matter?
Yes, sir.
All right, the court will appoint the public defender. Court finds probable cause on the charges alleged. What says the state?
Your Honor, to clarify, what is the defendant's name?
Raul Davila Nieves.
I see. Your Honor, considering the importance of actually obeying domestic injunctions and ensuring that defendants follow the law and the dictates of the court system, the state would recommend that the defendant continue to be held at no bond until he can be addressed by a trial court.
All right, is there a victim here? None, no?
Your Honor, she needs Spanish interpreter.
Oh, okay. Madam Interpreter?
Yes, Your Honor.
She is in fact here on this case, though? Okay. Ma'am, because this case against Mr. Davila Nieves involves a domestic injunction,
Señora, debido a que este caso en contra del señor Raúl Davila Nieves tiene que ver con una orden de alejamiento,
it involves your rights to a degree as the person who I believe obtained the injunction.
sus derechos vienen a relucir, obviamente, como la persona que obtuvo la orden de alejamiento.
You don't have to tell me anything. You're free to just simply come here to observe. On the other hand, if you would like the court to know anything in determining any matter at issue in this case, you can let me know.
Usted no tiene que decir nada al respecto, pero ya que usted es la persona que estaba involucrada en el caso, si hay algo que usted quiere que la corte sepa, usted tiene el derecho de dejarme saber.
Would you like to say anything as to this case?
Yes.
¿Desea decir algo en relación a este caso?
Sí, buenos días. Yo quería notificar que el día que a él lo arrestaron, él andaba conmigo en mi guagua. Yo estuve el día anterior en el hospital porque tuve un pequeño prolazo, lo cual ahorita mismo él pues trabaja con mi hijo. Y aunque nosotros no nos tengamos directo, pero ya yo veo que él no lo veo agresivo, lo veo muy tranquilo en su trabajo con mi hijo. Y pues yo no quisiera hacerle más daño porque él está alejado, yo estoy alejada, lo único que hice fue un favor.
I'm going to have you stop just because we need the interpreter to tell me what you're saying, and then you can continue.
The day that he was arrested, he was actually with me because I had a medical issue and I was in the hospital. So he was actually helping me. He works with my son. I see him changed. I see him calm. I don't see him aggressive or anything. He was actually helping me. I don't wish him any harm. I don't wish to do him any harm.
All right. Anything else?
Y entonces yo quisiera como que pues que si se pudiera anular porque él en sí lo que está es, yo no puedo hacer lo que ellos se separen porque pues él y yo tuvimos una relación y pues no fue la mejor, pero yo sé y entiendo que a pesar de todo él es una persona buena, responsable con su trabajo. Y no quisiera hacerle daño.
I would like this whole thing to be voided, null and void. I cannot keep him separate from our son. I mean, we did have a relationship. It wasn't the best relationship, but he is a responsible person and he is responsible with his work, and I don't wish him any harm.
All right. State, any input?
Yes, Your Honor. In light of the victim's testimony, the state would recommend that the court issue a bond amount of a reasonable amount and include no hostile contact as the order, so that the victim will have the opportunity to determine the extent to which she wants to interact with him.
All right. That
Your
sounds
Honor,
like a reasonable request.
One moment, please. La fiscalía está pidiendo que se le fije una fianza razonable y que no se le permita contacto hostil con la víctima, esto hasta que ella decida qué es lo que ella está dispuesta, qué contacto ella está dispuesta a tener o cómo ella quiere que las cosas sigan de aquí en adelante.
Claro. Estoy de
Your Honor,
acuerdo.
as to the bond set for the driving while license revoked, we ask that it be reduced significantly to $500. It's set at $2,500 now.
So that's the scheduled amount for a habitual offender, right?
We are allowed to differ from the scheduled
Sure.
number.
All right, and as to the violation of domestic injunction count?
To set a reasonable bond.
All right. Court sets bond on the violation of injunction claim in the amount of $250 and orders no hostile contact. Sets bond in the amount of $1,000 with respect to the habitual offender driving with a suspended license, revoked license charge.
El juez le va a fijar la fianza esto en $250 por la violación de la orden de alejamiento y se le pide, se le ordena que no tenga contacto hostil. En el caso de manejar con la licencia esto revocada como delincuente reincidente de tránsito, la fianza es $1,000.
And I'll just point out the obvious that, I mean, to the extent nothing's done about the injunction, this is going to continue to keep happening.
Y para que esté al tanto, hasta que no se haga algo con la orden de alejamiento, esto va a seguir ocurriendo.
All right, thank you.
Gracias.
Ah, permiso, ¿puedo hacer una pregunta?
Correct.
Excuse me, I do have a question.
Yes, ma'am?
Sí.
Adelante, señora.
La fianza de $1,000, no tiene un 10%.
The $1,000 bond, does it have a 10%?
You can talk, the defendant can talk to his lawyer about that.
El acusado puede hablar con su abogado sobre eso.
Y cuando mi niño estaría consciente a la fianza, porque él está conmigo aquí, ¿entiende? Y él es el que va a tomar la decisión de fiarlo, porque pues...
When will my son be made aware of the bond? He's here with me now, and he's the one that's going to bond him out.
You can talk to them downstairs about that, or a bail bondsman. I can't provide you any information on that.
Señora, usted puede hablar con ellos abajo en el primer piso sobre eso, o con un fiador. No le puedo dar más información al respecto.
Muchas gracias, que tengan buenas tardes.
Thank you.
Thank you very much. Have a good afternoon.
All right, Marcus Casita. All right, we're here in 2020 CF 2000. This is a reset. We're here on an initial appearance related to trafficking, charges of trafficking in MDA, petty theft, and possession of drug paraphernalia. Do you wish for the public defender to represent you in this case? All right.
Yes, sir.
Defendant said yes. Court appoints the public defender and has found probable cause based on a review of the arrest affidavit for the charges alleged. State wish to be heard.
Yes, Your Honor. Per the face sheet, the defendant has an open felony in Seminole County, an open misdemeanor in Seminole County, multiple pending warrants for failure to appear, a hold in Seminole County for failure to appear, and has no community ties that have been verified by PTR. Considering the risk that the defendant poses of not only committing new offenses, but of not appearing to court for the offenses that he's actually being charged with, the state would recommend that the court hold the defendant at no bond or at a high bond.
Defense?
Your Honor, defense would object to no bond. We would ask that bond be set at a reasonable amount on the 3 counts before the court today.
Court will set bond on the trafficking charge in the amount of $50,000 and with respect to petty theft and possession of paraphernalia at $500 as to each charge. Thank you very much. Tiffany Carter Hall,
Yes.
good afternoon.
Good afternoon.
We're here.
Excuse me, Your Honor. This is the interpreter. Are there any further interpreter cases?
I don't believe there are. No,
Thank you.
there aren't. Thank you. You're here this afternoon on a first appearance related to a charge of domestic violence battery. Do you wish for the public defender to represent you in this matter?
Yes.
Court appoints the public defender and finds probable cause for the charge alleged.
Your Honor, she does qualify for PTR, but I do want to bring to your attention in the police report, the victim told the officer she did not want to prosecute. We would ask that she be released on ROR.
No one here for this case? What says the state?
Your Honor, regardless of whether the victim wants to prosecute or not, the fact of the matter is that this is not the first time that the defendant has been arrested for battery domestic violence, and as such, the state would request a moderate bond be put in place. If the court does order release of any kind, the state would request that no contact, or at bare minimum, no hostile contact, be put in place as well.
Court will order pretrial release with no hostile contact as a condition. And that's as to Mary.
There you go.
All right, thank you. Brittany Messineo?
Yes, Your Honor.
Good afternoon. We're here for a first appearance related to a charge of petty theft. Do you wish for the public defender to represent you in this case?
Yes, please.
All right, the court appoints the public defender. I've reviewed the arrest affidavit and find probable cause for the offense alleged. Does any party wish to be heard as to bond?
Yes, Your Honor, we, defense asks that the bond stay as is at $250.
No objection from the state judge.
All right, court sets bond at $250 on the petty theft charge. Thank you. Good luck.
Thank you.
All right, good afternoon. This is case number 2020-1250, Christina Lynn Duran. Ms. Duran, you are here for a first appearance on charges relating to charges of misuse of 911 and resisting a law enforcement officer without violence. Qualify for appointment of the public defender, and do you wish for the public defender to be appointed?
Yes.
All right, court appoints the public defender to represent you in this matter. Does any party wish to be heard? Court finds probable cause for the offenses.
Yes, Your Honor, as to the bond on the misuse of 911, we'd ask that it be set at 100 instead.
And, Your Honor, the state believes that a total combined bond of $600 is appropriate. The court asks that if the court reduces bond amount on the 911 charge, that the resisting charge be increased commensurately.
Court will set bond on count 1 in the amount of $250 and count 2 in the amount of $100. Thank you, ma'am. All right, Martinique Carr?
Mm-hmm.
All right.
Yes.
We're here for a first appearance on charges related to battery by strangulation, false imprisonment, and assault domestic violence.
Mm-hmm.
Are there any victims here? No? Do you wish for the public defender to represent you in this matter?
Yes.
All right, court appoints the public defender.
I'll ask for
Does any party wish to be heard as to bond?
Yes, Your Honor. Defense would ask that we set bond at a reasonable amount on each count.
And, Your Honor, the state, noting the severe facts of the case, noting the behavior of the defendant, noting the possibility that if this incident ever occurs, it could in fact escalate to the level of a homicide, and recognizing that this is a dangerous offense per statute under which the court has the discretion, if it finds that the defendant poses a danger to the community or to persons within it on a physical level, hold the defendant without bond. If the court does impose bond, the state requests a high bond to ensure compliance with the court's edicts, and also no contact, no return, separate residences.
Your Honor,
Does
this,
your, go ahead, I'm sorry.
for the court to consider the possible intention of this escalating to homicide, it would be, the defense would object. That's purely speculation.
However, part of the reason why domestic battery by strangulation, and in fact all battery by strangulation, is treated more seriously is in part because of the fact that it can cause lasting damage in a way that most other batteries cannot, including the damage of death.
Does your client have belongings at the 1908 Conway?
Say that one more time,
Apartment.
Your Honor. He was talking to me.
Does he have belongings at the 1908 South Conway Road, number 137 apartment?
No.
No? Was he living there? My understanding is.
Yeah, I was living there, but,
Alternative address.
yes.
What'd you say?
He can go to a different address, Your Honor. He does not live there.
Okay. Court sets bond on the battery by strangulation charge in the amount of $3,500, false imprisonment in the amount of $250, and assault in the amount of $250, and will order no contact with the victims, Deandra Diaz, or her child, Josiah Diaz, no return to 1908 South Conway, and it sounds like he doesn't need to go back, but to the degree he needs to go back to retrieve any personal belongings, it'll be accompanied by a law enforcement officer. Thank you very much.
You're welcome.
All right. Are you Henry Garcia? You Mr. Garcia?
Yes, sir.
All right, Mr. Garcia, you're here on a first appearance on the following charges in 6 different cases: home invasion, criminal mischief, battery, burglary, criminal mischief, and harassment. You have the right to remain silent, and anything you say can be used against you. You have the right to counsel, but my understanding is you do not qualify for appointment of the public defender. Have you had the opportunity to contact counsel? No? Okay. Court finds probable cause for each of the charges alleged. State wish to be heard as to bond?
Yes, Your Honor. Home invasion robbery is a punishable by life offense in the state of Florida. As a result, the court should keep the defendant in custody so that at the trial court level, the state can proceed with a hearing on proof evident presumption grade. This is pursuant to the laws of the state of Florida, and if Your Honor would like to look to case law, Russell versus State, 71 Southern 27, Florida 1916, first laid the groundwork for the PEPG standard that will be applied at trial. However, the trial court is the one that has the full evidentiary hearing in order to determine whether to continue holding the defendant. In the interim, the state asks that the court hold the defendant without bond so that the trial court can have the opportunity to go through that analysis. This is because of the fact that the offense in question, seeing as how it could be punished by life in prison, is an offense that is not only particularly serious, not only particularly injurious to the community, but also one that has a particularly high flight risk. It also has a greater incentive for for instance, crimes of witness tampering or something along those lines. And as a result, whatever the court does with the other charges involved, including the criminal mischief, the harassment, et cetera, the state asks that, at least on the home invasion robbery, the court issue no bond to the defendant.
All right. Sir, is there anything you want the court to know in determining bond in this matter? You don't have to say anything.
Well, I pay rent in that place. I'm just not on the lease. I have proof with the checks numbers.
Okay.
And, Your Honor, the state would note that when evaluating proof evident presumption grade, the state, or rather the court, looks only to the sworn testimony that is presented in the arrest affidavit at the IA stage. Later on, the defendant can provide proof to attempt to, for instance, dismiss the charge or any sort of argument he may present at the PEPG hearing.
Based on the allegations in the arrest affidavit, the court finds it would not be appropriate to hold him without bond as to the home invasion charge. And instead, the court sets bond in the amount of $2,500 with respect to the home invasion charge, $1,000 with respect to $1,000 with respect to burglary, and then $150 with respect to the other misdemeanor offenses charged, for a combined bond of $4,100. Mr. Garcia, you were residing at 11850 University Boulevard, 241B at the time of this altercation?
Yes.
Do you have your own place elsewhere?
Yes.
As a condition of the bond, the court will direct no contact with the victim. Maintain separate residences. And to the degree, Mr. Garcia, you need to go back to that 11750 University Boulevard residence in order to obtain any of your belongings. You'll do so while accompanied by a law enforcement officer. All right? All right, thank you very much, sir.
That's okay. So battery, DV, how much is the bond? That's okay. The burglary was the one that you said, you reduced it to 1,000. And then the criminal mischief are both 150? Okay, got it. Thank you. It was just those 3 cases. Thank you.
All right, Jaquan Carter?
Yes.
Good afternoon, sir. You're here for a first appearance related to a charge of grand theft in the 3rd degree. You have the right to remain silent, and you have the right to an attorney. Do you wish for the court to appoint the public defender to represent you in this matter?
Yes, Your Honor.
Court appoints the public defender. I have found probable cause for the charge alleged in the arrest affidavit. Does any party wish to be heard as to bond?
Yes, Your Honor. Defense would ask that the bond be set at $250.
Your Honor, considering the fact that the state and court system both have a great interest in keeping the defendant in full compliance with the law lest he loses bond, the state requests that the court leave the bond as is, especially noting the fact that the defendant doesn't qualify for PTR because he's on probation in Seminole County, yet committed this offense anyways. Considering the fact that the defendant is not obeying court orders already, the state requests a bond of $2,500 in order to better motivate him.
Court sets bond at $1,000. Thank you. All right, Mr. German Ferrer? He bonded. All right, Stephen Haddon. Good afternoon, sir. You are here on a single charge of trespass on property without warning. Would you like for the public defender to represent you?
Yes.
All right, court appoints the public defender, finds probable cause for the charge alleged. What says the state?
Your Honor, if the defendant wishes to resolve his charge today, the state would ask for an adjudication of guilt, court costs, and credit for any time served. If the defendant does not wish to resolve his charge, the state would leave the matter in the court's discretion.
Defense would ask for a withhold court costs and credit time served to resolve today.
Your Honor, the face sheet indicates that he has an extensive history of trespass after warning, trespass generally, trespass with assault or battery, and a number of other offenses. Considering the criminal history of the defendant and the fact that he's no longer eligible for a withhold, the state would argue that an adjudication of guilt is appropriate.
Sounds like that's the offer, counsel.
If we could please to the bench for a withhold. His
Probably.
face sheet also says that he's got low risk, or a low risk assessment, so.
I'm sorry? Oh, okay. Given the history, I don't know that I'd be
I'll take
inclined to
it.
withhold adjudication.
Say that one more time.
Given the history, I don't think I'd be inclined to withhold adjudication.
Okay, he'd like to enter a plea of no contest.
No contest.
All right. You understand the terms of the plea that you're entering into and the rights you're giving up by doing so?
Yes.
All right. Court accepts the plea, adjudicates you guilty of the charge alleged. How many days? 2 days, credit for time served, and court costs within a year. Thank you, sir.
2 days? 1 day.
You should be, you got credit time served for 2 days.
You were sentenced to 2 days and you've been in for 2 days, right?
Yeah.
Okay. All right, Richard West?
Yes, sir.
Good afternoon, sir.
Good afternoon.
This matter was reset from yesterday. Mr. West, you're here for a first appearance on 2 counts of petty theft, a single count of trespass, and a further count of fraudulent refunds. Do you wish for the court to appoint the public defender to represent you?
Yes. Yes, Your Honor.
All right, the court appoints the public defender. I have reviewed the arrest affidavit and find probable cause for the charges alleged. Does any party wish to be heard as to bond?
Yes, Your Honor, defense would ask that the petty theft charge be reduced to $250 to align with the $250 on the other counts.
And Your Honor, in reflection of the fact that the 2 petty thefts are both 2 prior conviction petty thefts, those are felonies, the state would recommend that the court keep the bond as is.
Court sets bond on the petty theft claims in the amount of $500, $500, and as to trespass and fraudulent refunds, $250. Thank you. Good luck. Joseph Paul Dinkins?
Yes, sir.
All right. Good afternoon, sir. You're here for a first appearance related to a charge of open container. Do you wish for the public defender to represent you?
Yes, sir.
All right, court appoints the public defender to represent Mr. Dinkins. Court finds probable cause for the charge alleged. What says the state?
Your Honor, if the defendant wishes to resolve his case today, the state would offer adjudication of guilt, court costs, credit for any time served. Besides that, Your Honor, in terms of bond amount, the state would leave the matter in the court's discretion.
Does your client wish to resolve the case?
If we could resolve this with the withhold court costs, credit time served, looks like it's an open container charge. The allegation is that he had a beer on the sidewalk.
Are you pleading to the bench?
Yes.
All right. Court will accept the plea, withhold adjudication, award court costs, and was he in for 2?
Yes, 2 days.
And sentence you to 2 days with credit for time served.
He's entering the plea of no contest. I don't know if I said that. Yes. Entering this plea or giving up your fair trial. If you're not a citizen, this could subject you to deportation. Why do you have the right to an attorney and the right to appeal? Yes. They're usually like 300 a whole year to pay. I can't do anything. I have no idea. You'd have to see if maybe PTR can help you with that. Sorry.
Is there anything further?
Nothing further, Your Honor.
Okay, great. Thank you, sir.
Thank you, sir.
All right, Roger Francois,
Yes, Judge.
you don't need an interpreter, do you?
Pardon me?
Do you understand English fairly well?
Yes,
Okay,
Judge.
Great. I'll just make sure I speak clearly. You are here on a first appearance on charges related to battery and aggravated battery. You do not qualify for appointment of the public defender. You have not retained private counsel to represent you?
I defend.
Do you intend
I
to?
like to have the defender.
I don't understand, sir.
I like to have the defender, yes.
I think he's asking if the court could use discretion and appoint the public defender considering the circumstances.
I think that would be appropriate under the circumstances. Any objection?
No, Judge.
All right, court appoints the public defender temporarily to represent Mr. Francois.
Your Honor, defense would ask that we set bond at a reasonable amount of $250 on each charge. It looks like the alleged victim in this case does not reside at the home, and we can issue a no-contact order if necessary.
Is anyone present for this case? No? State?
Your Honor, I believe that particularly for an aggravated battery, I believe that bond would be dramatically inadequate. It's the state's position that the defendant should have a moderate to high bond imposed and should be ordered to maintain no contact with the victim. Just in case that there is some sort of dwelling issue, the state would also request that the court order separate residences. If they already live separately, it won't be an issue. If they do live together, contrary to the assertion of the defendant, then there would be an order in place about it.
Your Honor, the allegation is that he allegedly used his cane.
Based on what's contained in the arrest affidavit and considering the defendant's age as well, court will set bond on the ag bat charge in the amount of $500, the domestic violence battery charge in the amount of $250, and order no contact with Bernard Tilm or Tilme, and maintenance of separate residences, And I guess just make clear to your client that that means to the degree he comes over again to visit, I believe, his mother, Mr. Francois can't be there.
And Your Honor, he has an immigration hold.
Comes to visit, he cannot be in the house. Okay, so then he can't come to the house while you're there. He can't go to the house while you're there, as long as, tell his mom needs to tell him.
That's it, yes, you're right.
You cannot talk to him. Okay,
Right, Mr. Francois is also on an immigration hold.
yeah. So it's fine, he just can't come back to the house, this is for you.
All right, good afternoon. Ivan Lee Rosario?
Yes, sir.
All right. You are here on a first appearance related to a charge of aggravated battery on a pregnant person. You qualify for appointment of the public defender. Would you like the court to appoint the public defender to represent you?
Yes, sir.
All right, court appoints the public defender, finds probable cause for the offense alleged. Does any party have any input with respect to bond?
Yes, Your Honor. The state would note the fact that this also is a dangerous offense under the Florida state statutes and request the court consider the possibility of holding the defendant no bond. However, in the event that the court decides to set a bond, the state would request a high bond with a no contact provision.
Your Honor, this is not a capital offense nor punishable by life, so he's entitled to bond. We ask that bond be set at a reasonable amount of $500, and if the court wishes, it can order no contact with victim.
Mr. Rosario does not live at the 1103 Browning Avenue address?
Yes, I do, sir.
You do?
Yes, sir.
How long have you lived there?
I've lived there like 3 to 4 years, sir.
Do you have somewhere else you can go?
No, sir.
Court sets bond on the aggravated battery on a pregnant person in the amount of $3,500, orders no contact with the victim, Carmen Hernandez, maintenance of separate residences, and if Mr. Rosario seeks to go back to the 1103 Browning address, he must be accompanied by a law enforcement officer.
He's saying that you're gonna have to move out. One of you has to move out.
That's unaffordable. That's really gonna be something hard to really get accomplished. Oh, that's it. Thank you.
All right, Kasim Stevenson?
Yes, Your Honor.
Good afternoon. We're here on first appearance related to a violation of probation. I see you qualify for appointment of the public defender to represent you. Would you like the court to appoint the public defender?
Yes, Your Honor.
Court appoints the public defender. I believe the underlying,
Is the basis for the VOP.
I'm sorry?
It is the basis for the VOP,
The battery,
correct?
state?
Your Honor, the state would direct the court to note that it is a situation where there is a violation of probation and would refer back to prior arguments on that effect. With regards to this specific battery domestic violence charge, the state would note the inclusion of a firearm. Though the firearm was not discharged or anything like that in the offense, the state would note the fact that Your Honor yourself granted a search warrant that discovered the firearm itself. Considering the element of danger that the firearm adds to the situation, the state would request a high bond if Your Honor issued one.
Your Honor, the allegation for the domestic violence battery, The alleged victim is also a co-combatant, I believe, might have been arrested as well. And the firearm alleged in the police report was actually not used by Mr. Stephenson.
There's a bit of a conflicting part in the narrative, the arrest affidavit concerning reaching for weapons as opposed to pulling the weapons as opposed to threatening with weapons.
If we read the police report, there is no allegation that Mr. Kasim ever pulled out a weapon. The only weapon that is mentioned was pulled out by Mr. Gomez.
Around halfway down is the part that I was referring to, talking about the perception that the defendant was reaching for a weapon by the side of the bed. The firearm was found under a pillow on that bed pursuant to the execution of the search warrant. So I think that that is worthy of the court's consideration. I'm not arguing for no bond, Your Honor, but for a moderate to high bond.
Court will set bond in the amount of $5,000.
As to the battery?
I'm sorry?
As to the battery?
As to the violation of probation and the underlying battery.
Oh, I saw that the violation of probation already had a $1,000 bond.
That's what okay.
So the battery had no bond, and we're asking that it not be $5,000.
No, you're right. I'll stay the bond on the 1,000 on the violation of probation, set bond on the battery at 500. Has the state requested any conditions?
The state would request conditions of no contact and no return.
Defense wish to be heard as to the conditions?
Yes, Your Honor. Mr. Stephenson has advised that he will not reside at the residence going forward.
Okay, no contact, no return, separate residences. Thank you.
You cannot communicate with him.
Yes, ma'am.
Does your client need to return for any belongings? If so, accompanied by law enforcement.
Okay, perfect. You can go back one time with the cops and take your stuff.
Thank you. All right, James Austin?
Yes, sir.
All right, good afternoon. We're here on a first appearance related to charges of battery, dating violence. I see here you qualify for appointment with the public defender. Do you wish the court to appoint the public defender to represent you?
Yes, sir.
The court will appoint the public defender. Reviewed the arrest affidavit, found probable cause for the offense alleged. State wish to be heard?
Yes, Your Honor. Considering, well, first, Your Honor, there may be a victim that would like to speak first before the state makes a recommendation.
All right. Ma'am, since this is what we call a domestic violence claim, your rights are a big part of what the court needs to consider in determining where to go from here. All that having been said, you're not obligated to say anything. You can just sit here and observe if you'd like. Having said all that, is there anything you want the court to know?
Should I give the whole rundown, or?
I'll listen to whatever you want to tell me.
Okay,
I mean, I know the version of events that's set forth in the arrest affidavit, okay? So you don't necessarily need to go through any of that unless you dispute the factual information contained in there.
okay. Well, first of all, I don't feel safe around him. He has threatened to come to my family's home and kill us, I guess. I just don't feel safe around him. I'd like to seek an injunction or whatever I can to have him stay away from me. I did feel like In the event, like, that he was going to harm me further and that I probably wouldn't have made it out alive. So I just don't feel safe around him.
State have any inquiry of the witness?
Do you know of whether the defendant possesses any weapons, any firearms, knives?
He did tell me that he had his firearm in his bag. He never pulled it out, and I don't know if police did find it, but he did threaten to pull out a weapon.
How long have you known the defendant?
I've known him since June of 2018.
All right. And were you scared of the defendant at the time that this occurred?
Yes.
Are you scared of him now?
Yes.
Were you scared of him at any point prior to this event?
Yes. Before we made it back to our hotel room, we had a disagreement in the car, and he put his hands on me.
And no further questions from the state judge?
All right, defense?
Although I just want to bring to your attention, he does qualify for PTR, but in the alternative, we would ask that you set bond.
All right.
And, Your Honor, by way of bond, the state would argue, especially considering the facts contained within the arrest affidavit, which contain a sexual element and are frankly shocking to the conscience, that the court consider exactly how to proceed with the defendant. Were the court to issue a bond amount, the state would request it to be as high as Your Honor feels comfortable making it because of the severity of the offense. Furthermore, Your Honor, the state would request a no contact order, no return to the residence of the victim, no contact with any other family members of the victim, and no weapons.
All right, court sets bond on the battery claim in the amount of $5,000. Orders no contact with Kayla Polite, or Polity?
Yes, polite.
Polite or her family, and no firearms and any firearms to be surrendered to law enforcement. Did I cover each of the conditions?
Return to residence, Judge?
No return to the known residence of the victim or her family. Within 48 hours of release. Return of any weapons. Thank you. All right, Lynette Duran?
Yes.
All right, we're here for what we call a first appearance on a charge of domestic violence battery. I see you qualify for appointment of the public defender. Would you like the court to appoint the public defender to represent you in this matter?
Yes, please.
All right, court appoints the public defender. I found probable cause based on a review of the arrest affidavit.
And, Your Honor, her face sheet was updated. She would qualify for pretrial. She has no criminal history whatsoever.
None. All right. No criminal history. What says the state?
Your Honor, the state would request a moderate bond be imposed in addition to the pretrial release. If the court wants to choose one or the other, the state would request either a high bond or pretrial release with additional conditions. The additional conditions being no contact, no return, and maintain separate residences.
Your Honor, defense would object to all of those conditions. It looks like this could have been just a misunderstanding between the victim and her son over a family pet. It looks like the victim might actually live with the defendant. The victim also stated in the police report to the law enforcement officer that he doesn't want to prosecute. And we would ask that PTR or ROR be ordered, considering these circumstances. In fact, that they live at home together, if the court feels comfortable, can issue no hostile contact.
Court will release Ms. Durand on her own recognizance with an order of no hostile contact. Thank you.
This is for you. You're going to be released today on your own recognizance.
All right. Jesus Leon?
Yes, sir.
Good afternoon, sir. You are here on a first appearance related to a warrant for underlying charges of battery. You do not qualify for appointment of the public defender. Probable cause has been found to the underlying charge. And I believe, let's see, bond was not set by the judge who signed the warrant, was it?
That's the information I have, Judge.
All right, what says the state?
Your Honor, the state would request that the defendant be held no bond. To clarify, Judge, was this a new incident of domestic violence battery after the defendant was released pending charges or on probation for domestic violence battery?
Your Honor, if I may.
I'll temporarily appoint the public defender if you'd like me to.
Yes, sir, please.
I'll do that.
So first, I just want to bring to your attention, it looks like he qualifies for PTR. Had he been on probation in any other case, I'm not seeing that, and he wouldn't have qualified for PTR had that been the case. Also, it looks like this is not a capital offense, nor is it a punishable by life, so he's entitled to bond. We would ask that if Your Honor's not going to order PTR, that he be given a bond at a $250,000.
And Your Honor, the state's understanding of the case is that it originates with a underlying charge of domestic violence battery, and that this is a new offense. That's part of the state's justification for requesting no bond. If this is in fact the only charge that is present, which I'm currently looking into now, the state would request that the court, before making any final decision, hear from what appears to be the victim of the defendant's criminal acts, who is present in the courtroom.
Right, I think it is a single charge unless you correct me.
That's also what I have, Your Honor. I didn't see two separate.
All right, court previously found cause in relation to the arrest warrant for the charges alleged. Ma'am, you're here on this case?
Yes, yes, sir.
Okay. Because this is a domestic violence case and it implicates your rights, of course, too, we give you the option of, you can just show up and observe if you just want to know how the hearing resolves, or you can let me know whatever you think the court needs to know in setting an appropriate bond in this case. Do you want to talk to me about that?
Now, what does that entail? What do I have to tell you?
I can't tell you what to tell me. Are you here to say anything to the court, or are you here to observe?
I am in fear for my life, honestly, my and my daughter's life. He is very aggressive. He needs help, and that's all I wanted to have him seek and look for and help him with. He did, obviously, to the obvious, if you look at me, he did hit me, and it was 3 cases that I filed against him within a week's span. I don't know what else to say other than he needs counseling.
And Your Honor, the state has reviewed it. The defendant was not on probation to the state's knowledge at this time. However, the defendant did recently get off probation for aggravated battery domestic violence.
Okay, defense, anything further?
1 second, Your Honor, please. Your Honor, defense would ask that a bond be set at a reasonable amount.
And Your Honor, if the court is inclined to grant such a bond, the state would request that that bond be especially high, considering what has just been told to the court by the victim, and considering the defendant's prior history, which does include a number of domestic-related offenses, in addition to frequent violations of his probation, indicating that he is disinclined to follow the dictates of the court system and to fulfill his legal obligations, especially when it comes to refraining from hurting those he is in a relationship with. Were the court to issue such a bond, the state, as I said, would request that it be a high bond, The state would also request conditions of no contact and separate residences.
Your Honor, the defendant does not live with her.
Yep, I gathered that. Court sets bond on the battery charge in the amount of $500, orders no contact and the maintenance of separate residences from the victim. Thank you. All right, Brandon Lee, Michael Ortiz.
Yes, sir.
All right, good afternoon. We're here for a first appearance in this case on charges of battery, domestic violence, simple battery, resisting an officer without violence, and criminal mischief.
Yes, Your Honor.
I'm seeing in the documentation you qualify for appointment of the public defender. Would you like the court to appoint the public defender to represent you?
Yes, sir.
Okay, court appoints the public defender. I've reviewed the arrest affidavit and find probable cause.
He qualifies for PTR, Your Honor.
Your Honor, considering that the defendant also has a number of prior arrests, including a prior arrest for domestic violence battery, the state would be requesting a high bond be imposed for the defendant. And in any event, Judge, the state would be requesting no contact, no return, separate residences.
Your Honor, the face sheet I'm looking at says he's got no convictions in Florida, and we ask the court to take that into consideration.
And though he may have no convictions, he has a number of prior arrests. Of course, arrests weigh into the court's considerations differently, but especially when it comes to things like battery, domestic violence, very frequently these events occur, and then victims, for a variety of reasons, retract their willingness to cooperate, whether willingly or otherwise.
Does your client have somewhere else to go?
Yes, Your Honor, it looks like he does not reside with the victim.
It says they
Allegedly.
reside together as a family at the listed address.
He's advising
I'm
me no
moving.
longer.
Okay. Court sets bond on the battery DV charge in the amount of $500 and $100 as to the remaining charges. Court orders as a condition of the bond, no contact with the victim, no return to 3346 South Cimarron Boulevard, number 3. And to the degree Mr. Ortiz needs to return to the residence in order to get any personal belongings, he'll do so while accompanied by law enforcement.
And this is instead of PTR, correct?
Correct.
Your Honor, the next two are victims of each other. You want to bring them in side by side?
They are what?
They're victims of each other.
Okay. No, let's not do that. I don't think so. So you are Mr. Rivera?
Yes.
All right. Mr. Rivera, we're here on what we call a first appearance related to charges of battery domestic violence. You qualify for appointment of the public defender, so if you'd like, the court will appoint the public defender? Yes? Okay. State, anything?
Your Honor, the state, considering the defendant's prior history, admittedly, though most of his convictions, indeed all of his convictions that I'm aware of, were juvenile, the state would request that the court take into consideration the complicated nature of the offense, some level of prior history, including prior violent crimes as a juvenile, and simply impose a reasonable bond, taking that into consideration.
Defense?
Yes, Your Honor, he qualifies for PTR. Also alleged in the police report is that the victim was on her way out, as it is. So we would ask that the court order PTR as to the warrant that was served for FTA. It looks like he got a $200 bond on that. And we ask that, if anything, no contact with victim.
Anything?
One second. You have another case? Okay, so disregard the failure to appear. It looks like
Thank you.
that was closed or something.
Okay.
But as to the victim, it looks like they have reconciled, and she should be up here next saying the same thing, is what I'm being told.
Okay.
So,
Court sets bond in the amount of $500 and orders no hostile contact instead of PTR.
defense is asking for PTR, Your
I'm sorry?
Honor. He's asking for PTR. Is there any way we can order that if he qualifies?
In addition?
No, instead, it looks like the victim also qualified for PTR.
Your objection state was based on the prior juvenile history?
Yes, Your Honor, and the state understands that that's a relatively minor factor for the court to consider. The state just wanted to ensure that the court was considering it.
All right. Court reconsiders and will grant PTR, no hostile contact.
Thank you.
Thank you. Good afternoon, ma'am. You are India Sanchez?
Yes.
All right, we're here on a first appearance related to a misdemeanor charge of battery dating violence. And you qualify for appointment of the public defender. Would you like the public defender to represent you?
Yes.
Court appoints the public defender. I found probable cause for the offense alleged in the arrest affidavit. And does anyone need to air anything based on what we did last time?
No, just that we adhere to the PTR.
I don't really think that let's see.
Your Honor, the state would just request PTR and no hostile contact.
Okay. Court orders PTR, no hostile contact. All right, Monica Taylor Reed.
Yes, sir.
All right, good afternoon. We're here on what we call a first appearance on a charge of battery domestic violence. I see here you qualify for appointment of the public defender. Would you like the public defender to represent you in this matter?
Yes.
All right, court appoints the public defender. I found probable cause based on the arrest affidavit for the charge that's been alleged. State wish to be heard as to bond.
Your Honor, there appears to be a victim in the box that may wish to speak.
All right.
Yes.
Are you Michael?
Yes.
All right, sir. Since this is a domestic violence case, you can have your voice heard, so to speak, if you want it to, or you don't have to. So I don't want you to feel like you're compelled to come here and say anything. All that having been said, is there anything you want the court to know in determining how to proceed with respect to Monica?
First of all, As respect to like a bond, I mean, it's personal bond, but far as what's going on between us, you know, I'm in total fear. Last night was the first night I have been homeless. I did not sleep. My shoes have not been untied. I'm in the same clothes. I had to abandon the clothes that I did have because I couldn't carry them any further. I spent all the money I had on a cab and just had to, now I have, my total ownership of property is 2 backpacks and the pants that I'm wearing and underwear and socks. I transplanted here from Texas to marry her, and I came with 1 bag. I left a dog, my Chihuahua of 7 years, and now I have 2 backpacks and a land where I know absolutely no one, and with the threat that of her relatives will get me. You know, it was a terrifying night. I have not slept in over 30 hours. I have on the same clothes for over 30 hours. I couldn't drink water because I would have to use the restroom, and where would I go? I have to watch my stuff, which I end up losing anyway, well, just giving up. I do know about her, you know, her youth and growing up. It was a very abusive and you know, and sexual and just abusive. Anger management, I don't think she needs it, but some counseling, as much as the law allow. But she's, you know, as far as responsibilities, she got that, you know, but she has wrecked my life. I am in total fear because I don't know where her people are, you know. It was hard. For days, I've been trying to get to a safe house before this fallout. And it's just not there for men. But like I said, she needs some serious counseling, that long term, and, you know, no contact with me. You know, we live together, but I'm gone. When I leave here, I've got somewhere to go safe, and I don't really want to see her again unless it's in court.
So when you moved from Texas, did you move into the apartment 602 on 15300 West Colonial?
No, we were at 2121 Hiawassee.
Okay, and then you moved together to the West Colonial
Then we moved
apartment?
with her brother, and that's where everything went south.
Okay.
And then we finally, our place was ready, and by the time we got there, we had already, agreed to just live out the lease as
So you said
friends.
our place. Where's our place presently?
That was 15300 West Colonial Drive.
All right, and
which
that's
we
where the
moved.
incident occurred, and do you still have any belongings there?
I think I have a leather jacket. Whatever's there, I'm good. You know, I never want to go there again. I'm good.
All right, thank you. State, anything of the victim?
Your Honor, the state would ask the court to consider the victim's testimony in determining how to proceed. The state feels that a moderate bond is appropriate, but also a no contact order be issued. I know that the victim stated that he does not wish to ever see the scene of the crime again. However, the state would request, if it's at all possible, perhaps an order requiring the defendant, if released, to permit him to visit in order to reclaim belongings. And besides that, Your Honor, the state would leave it in the court's discretion.
Your Honor, defense would bring to your attention she does qualify for PTR. The victim did testify today that he has somewhere else to go. It looks like the apartment where this allegedly occurred is the defendant's apartment. So we would ask that even if we maintain separate residences, that the no contact order should not be a problem, considering the fact that he's already not planning to go back. if PTR is not available for Ms. Taylor Reed, we ask that a bond and the amount of $250 be ordered.
Right. Court will grant pretrial release, but obviously with conditions of no contact between the defendant and the victim, no contact between the defendant and the victim indirectly through others. Victim is permitted but not required to go back to the joint residence in order to obtain his belongings and will be accompanied by law enforcement if he chooses to do so. Anything else?
Nothing further, Your Honor.
Thank you, sir.
Thank you.
Even if he goes back, he has to go back with the police. He can't go back by himself.
Good afternoon, Calvin Williams.
Yes, sir.
Hello. We're here for a first appearance on a charge of battery dating violence. You qualify for appointment of the public defender. Would you like for the public defender to represent you in this matter?
Yes, sir.
All right, court appoints the public defender. I've reviewed the arrest affidavit and find probable cause for the offense alleged. We'll address bond, but I understand there is a witness present. Hello, ma'am. Because this is a charge of dating violence, I can hear whatever you have to say and that you think will assist the court in determining how to proceed for today's purposes. That having been said, I want you to understand you're not obligated to. So if you would like me to consider anything, you can go ahead.
In my opinion, what happened between us was kind of mutual.
Maybe pull the little mic a little closer.
What happened between us was pretty mutual. I'm not scared of him or anything. I think it was just like a heat of the moment. I wasn't hit or anything. It was just like pulling of a shirt and stuff like that. I'm not scared of him or anything. I just want him to get out if we could have like a low bond so he could hurry up and get back to work and not lose his job. And he lives all the way in Gainesville anyways. So I'm pretty safe. I feel I'm fine.
State, wish to make any inquiry?
Yes, Your Honor, briefly. Does the defendant own any weapons?
No.
Okay. Have you ever felt scared of him previously?
No, never.
Okay. Are you scared of him now?
No.
Okay. No further questions, Judge.
Your Honor, he qualifies for PTR. And due to the fact that he lives in Gainesville, we'd ask that if PTR is not available and according to the victim's testimony, he'd be released on ROR.
And Your Honor, if the court is not going to place the defendant on PTR, the state would request a low to moderate bond reflecting the testimony of the victim, but also the facts of the case and the prior convictions, some of which are violent of the defendant. The state would also request a no hostile contact order be entered so that the defendant and victim can still maintain contact with one another, but that the victim will have the opportunity to determine the bounds of that contact.
Does PTR create the possibility of him having to bounce between Orlando and Gainesville for the purposes of complying? I mean, I don't want to set him up for failure.
Correct. I believe he would have to check in, whether or not that's a phone check-in or a physical in-person check-in would be up to PTR.
Because he lives in the state of Florida at least once a month.
So due to that
Does
hardship.
he work in Orlando?
No, sir, I work in Gainesville.
Okay.
It looks like he was purely in Orlando to see the alleged victim.
All right. Court will set bond of $250 and order no hostile contact. Thank you. Right. Good afternoon, Alejandro Berenguer. Okay, we're here for a first appearance In this case, on charges of possession of heroin, resisting an officer without violence, and possession of drug paraphernalia. I understand you qualify for appointment of the public defender. Would you like for the court to appoint the public defender to represent you in this matter? All right, the court appoints the public defender. I've reviewed the arrest affidavit and find probable cause for the charges alleged. Parties wish to be heard as to bond.
Yes, Your Honor, for the possession of heroin, we ask that bond be lowered to 500 and that the other two remain the same.
Your Honor, the state would request that if the court lowers the bond of possession of heroin, that the resisting officer without violence charge be increased to 250. Other than that, Judge, the state leaves the matter in the court's discretion.
Court sets bond on the possession count in the amount of $500, and as to the remaining charges, $100 apiece.
I'm sorry, Your Honor, could you please repeat that? The bond.
$500 possession, $100 resisting, $100 possession of paraphernalia.
Okay, thank you.
All right, good afternoon. Willie Lee Carter? All right, here today on a first appearance related to charges of grand theft in the third degree of a motor vehicle. You qualify for appointment of the public defender. Would you like for the court to appoint the public defender for you?
Yes, sir.
Court appoints the public defender. I've reviewed the arrest affidavit and find probable cause for the charge alleged. Does any party wish to be heard as to bond?
Yes, Your Honor. The state would request that the bond either be kept as is or increased, reflecting the fact that the defendant has an extensive criminal history, including a large number of theft offenses. The state would ask the court take that into consideration when determining how to proceed with bond.
Defense?
Your Honor, we would ask that the bond remain at 1,000.
Court stays the bond at 1,000.
What's your name?
All right, Willis Gilbert?
Yes, sir.
All right, here for a first appearance related to charges of carjacking, grand theft, motor vehicle, driving with a suspended license with 2 prior convictions, battery, domestic violence, and criminal mischief. You qualify for appointment of the public defender. Would you like the court to appoint the public defender to represent you?
Yes, sir.
All right, court appoints the public defender. Found probable cause for the offenses alleged.
I don't even have an affidavit, sir, to know what's going on. Like I said, I work for Ultimate Alpha Project. I got my.
I don't want to talk on the record too much.
I don't
All
care
of
about.
this can be-
He's been on the record. I don't care. I mean.
Okay,
I
well,
wanna
you're
know what's
advised to
going
not
on.
talk on the record. It can be used against you. Everything is being recorded.
That's fine. That's
Well,
fine.
you can talk to I can give you a moment to talk to your lawyer if you'd like.
But I don't even have an affidavit. You know what I'm saying? When the police got in my aunt's house, they said they had a warrant for me. I don't know how. I don't know how. They said Apopka Police Department. They didn't say where this alleged crime happened at, what I did, or anything. I don't know. I have my time card from work all this week. My supervisor's name, Superintendent is Marion Edwards. I mean, I don't know.
All right, defense wish to be heard, I'm sorry, does the state wish to be heard as to bond?
Your Honor, I'm attempting to find the file for the defendant. The next one I had up was Harris. So I'm attempting to locate that. Did I hear Your Honor correctly that this is a VOP warrant?
There is none. That's what I'm saying.
No.
Okay. Oh.
No, he's out on bond with, on a number of,
Your Honor, permission to...
yes.
Thank you. I see, Your Honor. Well, first of all, Judge, the state would ask that the court revoke the bond previously permitted for the defendant's other offenses. One of the reasons why bond is permitted is to give defendants the opportunity to leave the custody of the court system in order to continue living their lives in a lawful way. The defendant hasn't lived his life in a lawful way. With regards to the current offenses being charged, the state would simply ask the court to set a reasonable bond in all amounts.
All right, defense?
Yes, Your Honor, we'd ask that the carjacking $5,000 bond on the warrant be reduced to $2,500. The grand theft motor vehicle $500 bond, we would ask that it be reduced to $250. The duelist, $250, and that you set a reasonable bond for the DV battery, and that the criminal charge stay the same at $250. And that you take no action on the bond he was already out on.
Your Honor, I work every day, sir. I don't know, I'm being honest, I really don't know what all this is about. Like I say,
Well,
I work
remember
every
what
day,
it was
sir. I
about.
go to,
This was the event, and it's not in front of me, but because I signed the arrest warrant, I remember it. This was, I believe, throwing a bottle at your girlfriend and then driving off in their car. Does that sound familiar?
no, sir, I was just with my daughter's mom yesterday. She actually Baker acted. We took her to get Baker acted yesterday at Aspire. She has a really bad drug problem. She's in Aspire right now. I took her to Lakeside, well, Aspire right down Mercy Drive yesterday. She's in custody over there right now, sir. So that's why I don't understand all this, and I have never been nowhere near a Popka. I mean, like, well, I don't understand.
All right, well, we'll get it straightened out.
I can't afford to
If it
lose my
needs
job. I got too
straightened
much going on right now, sir.
All right, the court sets bond on the carjacking count in the amount of $2,500, $250 with respect to the remaining charges. Are there any conditions that need to be imposed with respect to the domestic violence battery?
The Honor, the state would be asking with regards to that there be a no contact issued.
Your Honor, it looks like they do share a daughter in common, and if the alleged victim is at Aspire, we would ask that it be no hostile contact, and in case he needs to facilitate anything with their daughter.
All right, court order, no hostile contact.
Yeah, I was at Aspire with them yesterday, sir, trying to.
Once again, you're being advised not to say anything on the record.
All right, and I'll take no action on the existing case for which Mr. Gilbert is on bond.
Here you go. Hey, Michael. So, it looks like they arrested you for possession of cocaine and drug trafficking.
Yeah, we didn't get it.
All right, Michael Harris?
Yes, sir.
Here on a first appearance related to possession of cocaine and drug paraphernalia. You qualify for appointment of the public defender. Is that what you request?
Yes, sir.
All right, public defender represents you, Mr. Harris. The court finds probable cause for the offense alleged. Any party wish to be heard as to bond?
Yes, Your Honor. Defense would ask that the bond be reduced to $250 on the possession of cocaine and that it stay on the $100 for drug paraphernalia.
Your Honor, in the interest of the defendant not gaining further access to or continuing to use or possess controlled substances, the state would be requesting that the bond remain as is and would point the court to the fact that it's been less than 6 months since the defendant's last felony drug conviction. He also has an extensive conviction list relating to the use or possession of controlled substances, and the court, in the opinion of the state, should take that into consideration.
Did you request a particular bond, defense?
$250, I think I said.
That's what I read. Right, court imposes bond in the amount of $250 as to the possession of cocaine charge and $100 with respect to the possession of drug paraphernalia charge. All right, Anthony Meter?
Yes, Your Honor.
Okay. Here for a first appearance with respect to 5 counts of possession of cocaine and 1 count of possession of drug paraphernalia. You do not qualify for appointment of the public defender. Court finds probable cause for the charges alleged. State wish to be heard as to bond.
Yes, Your Honor, state merely requests that the bond remain as is.
Court stays the bond as to all counts.
Your Honor, I would ask if I could get that reduced too. As you can see, there are 5 singular items that were identified, and he stretched them all to 5 separate charges. In normal cases, from what I've seen, I have not been in trouble in a very, very long time. I turned my life around and, going through a bad divorce. Not saying that it's, acceptable, but, I'd like to get back out there. I do have a business that I've been operating and running, and again, I've stayed out of trouble. I asked that if I could at least get the bond reduced and get back out there so I can, get back to my business, stay out of trouble like I have been for a very long time.
I can reduce the bond on the initial possession charge to $500. Keep $150 as to the remaining 5 charges. No, I'm sorry. Let me just start from the top. $500 as to the first count for possession of cocaine, $150 for each of the 4 additional charges for possession of cocaine, and $100 for the drug paraphernalia charge.
Okay, so they're all still going to say remain 5 separate charges for...
Yes, I mean, that's how it's charged.
Okay.
So, all right, thank you. Gregory Phillips, bonded. All right, Charles Antoine Smith?
Yes, sir.
All right, we're here for first appearance on 2 cases. The first relating to charges of possession of cocaine and drug paraphernalia, and the second for open container. Court appoints the public defender to represent you. Finds probable cause as to the offenses alleged. Does any party wish to be heard as to the amount of bond?
Yes, Your Honor, as to the possession of cocaine, we would ask that it be reduced to $250, the drug paraphernalia $100, and the open container that he be ROR'd.
State?
Your Honor, state would request that the possession of cocaine remain at $1,500, the possession of drug paraphernalia $100, ROR as to the open container.
Court sets bond as to the possession charge in the amount of $250, $100 as to drug paraphernalia, and Mr. Smith will be released on his own recognizance with respect to the open container charge.
Thank you, Your Honor.
Thank you. All right, Trevor Dean Stillwell?
Yes, sir.
Good afternoon, sir. Here on a first appearance related to charges of shoplifting, resisting an officer without violence, and retail petty theft. You qualify for appointment of the public defender. Do you wish for the court to appoint the public defender for you?
Yes, sir.
All right, public defender is appointed. Court has found probable cause based on the arrest affidavit for the charges alleged. Does any party wish to be heard as to bond?
Yes, Your Honor, as to the use of the anti-shoplifting device, we'd ask that it be reduced to $250 and that the other two counts remain the same at $100.
Your Honor, the state would be requesting that the bonds remain as they are currently listed.
Court sets bond as to the shoplifting charge in the amount of $500, resisting $100, and petty theft $100. No return to the scene.
Thank you.
Thank you. Ray Stiles?
Yes, sir.
Good afternoon, sir.
How you doing, man?
Here for our first appearance with respect to possession of methamphetamine, MDMA. You qualify for appointment of the public defender. Would you like for me to appoint the public defender?
Yes, sir.
All right, PD is appointed to represent Mr. Stiles. Court's reviewed the arrest affidavit and finds probable cause for the charges alleged. Defense, what says the defense is to bond?
Your Honor, we ask that it be reduced to $250 and that you take no action on the other case that he's out on.
And Judge, because of the fact that, as the state has noted previously, the purpose of being out on bond is that you can continue living your life. You're motivated to further attend court and to live your life without committing any new offenses. And considering the fact that that did not work on the defendant so far, the state would request that regardless of what the court does with the bond on the MDMA charge, that with regards to the prior offense for which the defendant was out on bond, the court revoke that bond.
Mr. Stiles still employed?
Yes, Your Honor.
Court will set bond on the new charge in the amount of $250 and take no action on the underlying case for which he's out on bond. All right. Is it Sierra or Kiara?
Sierra.
Sierra Subs. Good afternoon.
Good afternoon.
Here on an initial appearance with respect to a failure to appear on underlying charges of possession of cocaine and petty theft, and new charges for introducing contraband into a county facility and possession. You qualify for appointment of the public defender. Would you like me to appoint the public defender?
Yes.
All right, PD is appointed. All right, any input from the state?
Yes, Your Honor. The state would leave the bond amount for the new charges in the court's discretion. However, because there is a failure to appear warrant, the bond on that warrant cannot be adjusted by the court. The state has those cases readily at hand, but as listed under the court previously.
No bond on the,
Failure to appear?
I'm sorry?
On the failure to appear, no bond?
No bond on the failure to appear shall be held for transport, I guess, to Seminole County. Court sets bond on the possession and introduction of contraband counts in the amount of $1,000 as to the introduction of contraband and possession $100.
And we ask that you take no action on the existing.
Court will take no action on the existing case for which she's on bond. Thank you, ma'am. All right, Jimmy Williams?
Sir?
We're here for a first appearance on a charge of petty theft with 2 prior convictions. You qualify for appointment of the public defender to represent you. Do you want me to appoint the public defender to the left?
I'd like to throw myself on the mercy of the court today because
All right.
I was drinking and probably need to get to a rehab or something.
All right. Court appoints the public defender.
I thought he said he did not want the public.
Is that what you said?
I'd like to throw myself on the mercy of the court.
Okay. Can the state make an offer?
Your Honor, this is Mr. Jimmy Williams, correct? Petty theft, 2 prior
Yes.
offenses? Your Honor, I don't feel comfortable making an offer because of the fact that an existing administrative order prevents IAs from settling basically any enhanceable offense, though it appears to already be enhanced here. In this specific charge, these charges can always be finicky. These charges may be changed in the event that this reaches a trial court. And further, Judge, I'm not sure that it matters in terms of my jurisdiction, but I am actually a county court attorney at the moment. So I don't know if I can resolve a felony charge. Incidentally, Judge, the administrative order is 2003-39-17, Section D.
How about a recommendation as to bond?
Recommendation as to bond, Judge, I will leave it in the court's discretion.
Court sets bond in the amount of $100. Thank you, sir. All right, Anthony Wilson? Is that you, sir? Anthony Wilson?
Yes, sir.
All right, we're here on a first appearance related to charges of burglary of a structure, grand theft of a motor vehicle, grand theft motor vehicle, criminal mischief, and grand theft in the 3rd degree. Qualify for appointment of the public defender. Would you like the court to appoint the public defender?
Yes, sir.
All right, court appoints the public defender. I've found probable cause for the offenses alleged in the arrest affidavit.
Your Honor, defense would ask that we reduce the bond on the burglary of structure and that the other counts remain the same at $150.
State.
Your Honor, state would request that the bonds all remain the same, and further, the state would also request no return to any of the locations, no contact with any of the victims.
Court sets bond on the burglary claim in the amount of $1,500 and $150 as to the remaining counts. No contact and no return. And let's just further elaborate the return. What is 2309 South Orange Blossom Trail? JK&M Auto Sales, okay. No return to JK&M Auto Sales. All right, thank you.
Are you Jonas?
All right, Jonas Darrenville?
Yes.
Right, we're here for a first appearance in this matter related to a warrant for a failure to appear on an underlying charge of trespass. Qualify for appointment of the public defender. Do you want the public defender to represent you?
Yes.
He previously what?
The public defender was previously appointed. This is
That's right.
It looks like that warrant, Your Honor, had a $2,000 bond.
Wait, state wish to be heard?
And it would have to be left at 2,000 to the understanding of the state judge.
Yep, court stays the bond on the underlying claims. Thank you. Good afternoon, sir. Anthony Rivera?
Yes.
All right, we're here for a first appearance related to a failure to appear on a disorderly conduct charge for which bond has been set in the amount of $200. Are you requesting that the court appoint the public defender to
No,
represent?
no, sir.
No? All right,
I'm just gonna plead guilty.
okay. State court's going to stay the bond,
Yes, Judge.
stay the bond as to the amount of $200. Thank you.
But I'm pleading guilty.
Well, you'll have the opportunity to do that later, once you bond out. Thank you.
I can't bond out no money. I just want to plead guilty, get it over with today. That's it. You can't force me to go to court.
Thank you, sir. All right. Timothy Aponte Rosario?
Yes, sir.
Okay, here for a first appearance related to charges of DUI with a prior conviction, driving while license suspended, and refusal to submit to a DUI test. I think you qualify for appointment of the public defender, so would you like for the public defender to represent you in this matter?
Yes.
Okay, PD is appointed for Mr. Aponte Rosario. Court finds probable cause for the offenses alleged.
Your Honor, defense would ask that we reduce the bonds on each count to $250 each and that you take no action on the existing case.
State?
Your Honor, I'm unclear as to the status of the existing case, whether that was a bond, an ROR, or what have you. The state, it was a bond, Judge? The state would request that the court revoke that bond for the arguments previously stated by the state and leave the bond in this case as is.
It's currently scheduled for arraignment on February 19 in Ocoee on the existing.
Okay. The date of arrest was January 31st, and this date of arrest is 2/15. So the court will keep bond as is with respect to the DUI on the prior conviction, so that's $500. Driving while license suspended, $500, and refusal to submit to the DUI test. Actually, have you requested a reduction as to those?
Yes, Your Honor.
Can you run through that again for me?
I think I originally asked for $250, but if we're keeping the DUI prior conviction set at $500, I'd ask that the other two be set at $100.
Right, that's appropriate. Court reconsiders, sets bond in the amount of $500 on the DUI prior conviction and $100 as to driving with a suspended license and refusal to submit to a DUI test. Court revokes the bond on the prior case for driving under the influence. Thank you. All right. Anissa Ayala?
Yes.
All right, we're here for a first appearance in this case on a failure to appear on an underlying charge of driving with a suspended license. We wish for the court to appoint the public defender to represent you.
Have a public defender.
Yes?
It looks like we were previously appointed.
Okay.
We can confirm that.
All right, anybody wish to be heard? Bond set in the warrant at $1,500.
Judge, the court should leave the bond stayed.
Your Honor, on the existing case, it looks like she had multiple court dates on the same date, and she did show up to court. It could have been a miscommunication in paperwork. We ask that you take no action on the existing case.
Court will stay the bond in the amount of $1,500 and take no action as to the existing case.
Your Honor, the case that she was out on bond, the bondsman has endorsed it, so she is being held on a $1,500 bond on that case. They endorsed the bond. She never went to IAs on that, she bonded before IAs, so just.
Right, she is out on bond in that case, right? And I'm not revoking it.
Right, but
So-
she is being held on it because the bondsman came off the bond.
Okay.
Your Honor, could we set a lower bond then on that case? If it's set at 1,500? The out-of-bond case, we can't touch the FTA at 15.
And Judge, I'm not sure exactly how the mechanics of that work with regards to the existing case, since the bondsman is involved in what's going on with that. I think that it would be more appropriate to permit the trial court to handle that.
What's that?
You can just take no action. It's already been endorsed.
Yeah, I'll take no action and they'll determine how that plays out. All right. Akeem Bridges? Good afternoon, sir. Here for an first appearance on a charge of driving with a suspended license. You do not qualify for appointment of the public defender. Anything you say can be used against you, and you have the right to remain silent. Court's found probable cause for the offense alleged in the arrest affidavit. State wish to be heard?
The state would request that the court just leave the bond as is.
Court sets bond on the driving with a suspended license charge in the amount of $500. Thank you.
The two out on bond.
Yes.
No.
No action.
Okay, thank you.
Sorry, again, one of them was endorsed, so same situation.
Okay.
Mr. Bridget bonding on,
I'm sorry?
Mr. Bridget bonding,
Okay.
and also Winston Latson bonding.
Do we have any information on Arrigo Noriega for a DUI? Did he bond out as well? It's, his booking number is 2000-4686. Thank you.
All right, Vincent Bo?
Yes, sir.
Good afternoon. We're here on a first appearance related to a charge of petty theft. You qualify for appointment by the public defender, so if you want, the court will appoint the public defender? Yes? Is that what you want?
Okay.
Okay. Court appoints the public defender to represent you. I've found probable cause for the charges alleged. Anyone wish to be heard from as to bond?
Yes, Your Honor, it looks like the merchandise valued at $144.84 was recovered. We would ask that the bond be reduced to $250 instead of $500.
The state requests that it be left as is.
Court sets bond in the amount of $500. Thank you. Darren A. Fox? All right, we're here for a first appearance related to a charge of petty theft. Do you want the public defender to represent you? All right, court appoints the public defender. The public defender finds probable cause for the charge alleged. Does any party wish to be heard with respect to bond? I understand this is related to the previous defendant's case.
Defense would ask that the bond be reduced to $250.
And state request 500.
Court sets bond at $500. Thank you. Michael Foy? Here for a first appearance on a charge of petty theft.
Yes, sir.
Qualify for appointment with the public defender. Would you like the court to appoint the public defender?
Yes, sir. Now, also, I'd like to ask the court if we can resolve this today. And
We'll get to that.
okay.
So the court will appoint the public defender, find probable cause on, as to the charges alleged. State have anything to offer?
Your Honor.
This is a felony.
Again, Your Honor, this is a potentially enhanceable offense that the administrative order prevents us from resolving today. However, considering the low value of the items stolen, the state would recommend that this court set bond in the amount of $250 as opposed to $500.
Defense?
No objection to bond being set at $250.
All right, court sets bond in the amount of $250. If you'll just explain to your client that we can't really resolve it today.
Your attorney.
Jalen Griffin? Bond? Bryce Howard?
Yes.
Right, we're here for a first appearance in this matter related to a charge of petty theft. You qualify for appointment of the public defender. Do you want the court to appoint the public defender to represent you here?
Yes.
All right, court appoints the public defender. I've found probable cause for the charges alleged. There's an existing case for grand theft in the third degree, which is pending with an arrest date, or bond date of 1/21/20. What says the state?
Your Honor, the state would request that the bond be revoked, not only speaking to the state's prior arguments with different defendants about the important role of bond and the importance of maintaining lawful conduct during release on bond, but these are also, as noted by the nature of the charges, very similar offenses. As a result, the state would recommend that regardless of what the judge does with regards to the bond on this case, that the bond as to the existing case be revoked.
What says the defense?
Your Honor, no objection to the petty theft being stayed at $250, but we ask that you take no action on the existing case.
Given the proximity of the two events, the court will revoke the bond in the prior case and set bond in the new charge of petty theft in the amount of $250. Michael Logan?
Correct. Here. Good afternoon, Your Honor.
Good afternoon. Here for a first appearance related to 7 charges of misuse of the 9/11 system. Court, the court can appoint the public defender to represent you in this matter if you wish.
Yes.
All right, court appoints the public defender. I found probable cause for the charges alleged. What says the state as to bond?
Your Honor, with regards to this offense, it appears that the defendant would be eligible for a plea if the defendant wished to resolve it today. The state would offer an adjudication of guilt as to one count, withholds as to the rest, and a letter of apology to the dispatcher. If the defendant does not wish to resolve the offenses today, the state recommends that the court keep the bond as is.
I understood the terms of the offer to be adjudication of guilt as to one charge and then ROR as to the remaining charges?
For the offered judge, it would be adjudication on one charge, withhold on the rest of them, yes. And the court costs would only be assessed once, since it would be all resolved simultaneously. That is, of course, if the defendant wishes to resolve today.
have a moment, Your Honor?
Sure.
Your Honor, defense would like to plead to the bench and see if we can do the withholds on all counts. He does have some credit time served to justify some of that. No objection to the letter of apology, so, and the court costs only found on one count, not on all 6.
Yeah, and, Your Honor, just in justification for the adjudication of guilt, the defendant does have prior instances of arrests for resisting an officer without violence, out-of-state convictions for resisting, and for disorderly conduct. Though those are not identical charges, they're substantially similar enough that the state believes they should be considered priors and the defendant not be eligible, or rather entitled to a withhold, and instead have an adjudication and 6 withholds.
Your Honor, defense would argue that none of those previous convictions are related in any way, shape, or form to the offense that is before the court today. He doesn't have any felony convictions, and the face sheet I'm looking at says he's only has 2 prior misdemeanors. We would ask that the withhold still be allowed. It looks like he doesn't have a high average for risk assessment. And he has never been convicted or arrested for misusing 911 in the past.
And, Your Honor, the entitlement to a withhold is only on your first offense, not on your first offense of each type. The state would also note that the idea of resisting a police officer without violence is much the same abuse of the system as abusing the 911 system, which is part of the state's justification for the adjudication. Those prior offenses, you'll note on the face sheet, are convictions out of state.
Your Honor, there's no rule that says that he cannot have a withhold after
And-
a first offense.
And, Your Honor, the state doesn't believe that there's a rule that states all further offenses after your first ever criminal offense have to be adjudications. There's just no entitlement, as the state said.
All right. Mr. Logan, have you had the opportunity to speak with your counsel about the consequences of a plea to the bench?
Yes.
All right, and you understand you're giving up certain rights, including the right to present evidence of your innocence at a trial of this matter if you plead to the bench? Okay. On the defendant's plea to the bench, the court will withhold adjudication as to all claims. How many days?
2 days.
2 days. Sentence of 2 days with credit for time served and court costs as due a single count, single charge.
And, Your Honor, the state would still request that letter of apology be imposed because of the defendant's admitted conduct towards the 911 dispatcher.
And as a further term of the sentence, a letter of apology to the 911 operator.
Your Honor, this is a plea of no contest.
Okay.
We're asking for 360 days to pay.
Letter of apology in 30 days, 60 days to pay court costs?
You'll have 30 days to do the letter of apology. And 360 This is a record of court. It should be documented. Your Honor, just for clarification, if we could make sure the name of the dispatcher that to whom the letter of apology is to be addressed can be put on that order.
And, Your Honor, I don't know the name of the dispatcher. I believe that if the defendant provides the letter of apology to the clerk of the court, the clerk would be able to either provide the letter to the appropriate individual or in the alternative to contact the state attorney's office for the name. Furthermore, I could give my contact information to defense counsel. Defendant could reach out to defense counsel and get the name.
I've written in that the letters to be filed with the clerk of court and served to the state.
Okay.
All right. Thank you.
You're welcome.
All right. Are you Yolinda Martinez? All right, I didn't think you were. Stephen Qualls?
Yes, yes, sir.
All right, we're here on a first appearance related to a charge of resisting an officer of the law without violence. You qualify for appointment of the public defender. Would you like me to appoint the public defender to represent you?
Yes, sir.
All right, the court will do so and finds probable cause for the offense alleged. State have anything to say with respect to bond or otherwise?
Request to leave it as is, Judge.
Your Honor, defense would request that it be reduced to $250.
Court will set bond at $250.
You're done. You're welcome.
Alan Roan?
Yes, sir.
All right. We're here on a first appearance related to a misdemeanor charge of petty theft. You qualify for appointment of the public defender. Would you like the court to appoint the public defender for you?
Yes, sir, I would.
All right. It's done.
For PTR.
Your Honor, considering the extensive history of the defendant, the state would recommend that the court instead impose a bond in the amount of $500. Regardless, the state would simply ask the court to impose a condition of no return to the store.
Court will grant pretrial release, the added condition of no return to the store in question. Colin Edward Smith?
Yes, sir.
Good afternoon. We're here for a first appearance related to a charge of trespass on property after a warning. You qualify for appointment of the public defender. Would you like the court to appoint the public defender?
Yes, sir.
Public defender is appointed. Court has found probable cause based on the arrest affidavit.
Your Honor, defense is asking that the bond be reduced to $250, and if you feel comfortable, no return to Disney property.
And, Your Honor, the state would be requesting, considering the offense and the defendant's criminal history, which, while not specifically trespass after warning, but rather a series of thefts and burglaries, that the court impose that bond of $500 and the condition not to return to any Disney property. If the defendant wanted to resolve his case today, the state's offer would be an adjudication of guilt, court costs, and no return.
Okay. Your Honor, defense is asking to resolve the case today with the plea of no contest to the adjudication of guilt, court costs, and no return to the scene.
Right, do you understand the terms of the plea that you're agreeing to?
Yes, sir.
And the consequences and the rights that you're giving up by agreeing to that plea?
Yes, sir.
All right, court accepts the plea for adjudication of guilt, court cost, no return, time served, and no return to any Disney property. Thank you.
And we're asking for 360 days to pay.
360 days for cost.
Yes. Your paperwork should be released. You're welcome.
Gary Smith?
How you doing, sir?
I'm all right. How are you?
Okay.
Here for a first appearance on a charge of trespass in an occupied structure. Would you like for the public defender to represent you?
Yes, sir.
All right, the court appoints the public defender, finds probable cause for the offense alleged. State?
Your Honor, the state would request the bond remain at $500 and the defendant be ordered not to contact the victim nor to return to the location.
Your Honor, if we could hear an offer from the state.
Your Honor, this is a victim offense, and under Marcy's law, I can't extend an offer without speaking to them.
In that case, we'd ask that the bond be reduced to $250.
Bond will be set at $250. Conditions of bond are no contact and no return. Thank you. All right, Gregory Trowbridge?
Yes.
All right. You're here for a first appearance on a charge of trespassing in a structure or conveyance. You qualify for appointment of the public defender, so if you want to, the court will appoint the public defender for you.
Yes.
Public defender is appointed. Court finds probable cause for the charge alleged. Does any party wish to be heard?
Yes, Your Honor, we ask that the bond be reduced to $250 and that you take no action on the existing case.
State?
Your Honor, state requests that the bond stay as is, revoke on the existing case.
Court sets bond at $250 on the trespassing charges, takes no action with respect to the existing case for which Mr. Trowbridge is released on his own recognizance.
So,
So you can pay the bond to get out, and then you still have all the
how do we, I can't get it resolved today, can you not please? I can't pay the bond.
The attorney will be yeah, so.
All right, Mr. Garcia?
Yes, sir.
Okay, here for a first appearance related to a warrant out of Highlands County for failure to appear in that jurisdiction on battery charges, and there's been a bond set at $5,000 on the out-of-county warrant. I mean, I think the court will just, well, does the state have any input?
No, Your Honor. I think I know what you're about to say.
All right, just stay the bond. Unless he bonds out, he'll be transported. You will be transported, sir, to Highlands County with respect to those charges there, okay? But the bond's been set, so you can still get out. It's just a matter of whether you do it before or after you're transported. All right, thank you.
Thank you.
Xavier Graham?
Yes, sir.
All right, sir. We're here on a first appearance. You are here on an out-of-county warrant arising out of charges of failure to appear on a driving with a suspended license charge in St. Lucie County. There is no bond set for that failure to appear, so you'll be held on no bond pending transport to St. Lucie County on those charges, okay? Thank you.
And then you have city and county.
All right, Taryn Burks?
Yes.
All right, we are here for a first appearance related to Claims of burglary of an unoccupied conveyance, as well as grand theft of a motor vehicle. Case reset from yesterday. You qualify for appointment of the public defender. Do you wish the court to appoint the public defender, Mr. Burks?
Yes.
Okay, court appoints the public defender. Finds probable cause for the charges alleged. Does any party wish to be heard with respect to bond?
Yes, Your Honor, we ask that the 2,500 be reduced to 500 and that the vehicle theft remain at 100.
Your
And
Honor, it's-
50, sorry.
Oh, pardon me.
Go ahead.
State would simply request that the bond remain unchanged and that there be no contact with the victim.
Is there any issue with no contact?
One second.
For the record, Judge, the arrest affidavit indicates that the victim didn't know who the defendant was, a person by the name of Mr. Williamson.
That is correct, Your Honor. No contact should be fine.
Okay, court sets bond on the burglary charge in the amount of $500, the vehicle theft charge in the amount of $150, and orders no contact with the victim. All right, Christopher East.
Yes, sir.
You're here on a first appearance related to charges of burglary, grand theft in the third degree, possession of cocaine, and criminal mischief. You qualify for appointment of the public defender. Would you like the court to appoint the public defender to represent you?
Yes, sir.
Okay, the court appoints the public defender. I found probable cause based on the arrest affidavit for each of the charges that has been alleged. I understand there's a prior case involving driving with a suspended license.
Yes, Your Honor, defense would ask that you take no action on the existing case and that we reduce the burglary structure bond to 500 and that the other counts remain the same.
Reduce burglary to 500?
Yes.
And Judge, considering the seriousness of burglary of a structure as a charge, and considering not only the facts of the case, but the criminal history of the defendant, which includes extensive grand theft arrests and convictions, the state would request that the bond be kept as is and the defendant be ordered not to return to the scene and not to have contact with the victim.
Court will set the bond on the burglary charge in the amount of $1,500, grand theft $150, possession $150, and criminal mischief $100. No contact ordered and no return to the scene ordered.
And is that no action on the existing?
Oh, yes, no action on the existing case.
Thank you.
Okay, Williamson Louis Jean. Here on a first appearance related to resisting an officer without violence. You qualify for appointment of the public defender, so the court will appoint the public defender. Court finds probable cause for the charge alleged.
Your Honor, defense would argue, would ask that the resisting bond be set to ROR. The allegation in the police report is that Mr. Louis was jaywalking and that he walked away while the cop was asking him to stop. Although the nature of the charge is without violence, we would argue that there is no justification for a $500 bond due to the facts.
State wish to be heard?
Your Honor, I think that that's an appropriate argument to make to the prosecutor with regards to a potential plea deal. For the moment, the state would request that the bond remain as is.
Court will release Mr. Louis Jean on his own recognizance with respect to the resisting officer without violence claim. Okay, Don Eric Wilson,
Mental health, Your Honor.
mental health. Reset.
Which was that, Judge?
Don Eric
Oh,
Wilson.
Don Eric Wilson. Thank you.
Are you Victor Morales? He's on an ice hold.
We've got Forbes, Curtis Forbes.
For,
Is this Mr. Forbes? You said Mr. Forbes?
Yes.
Okay, excellent. All right, Mr. Forbes, we are here today on a first appearance related to a violation of probation on fleeing and eluding, a warrant on a failure to appear for driving with a suspended license, and new charges of possession of cocaine with intent to sell and deliver, and possession of, what was the additional possession charge?
Cannabis less than 20, Judge?
Cannabis less than 20. All right, you qualify for appointment of the public defender. Would you like me to appoint the public defender for you?
Yeah.
Okay, the court appoints the public defender. I found probable cause for the, let's see, the new charges. Does anybody wish to be heard with respect to the bond on the new charges?
Yes, Your Honor, we ask that the intent to sell, deliver charge be reduced to 1,000, and that the possession of cannabis be reduced to 100.
And, Your Honor, the state would recommend on the new charges that the bond remain as is on the cocaine, that the defendant be ROR'd as to the cannabis, and that as to the $1,000 failure to appear and the no bond VOP, that those remain in place per the case law previously cited.
Sure. Court will set bond on the new charge of possession of cocaine with intent to sell and deliver in the amount of $7,500, possession of cannabis in the amount of $250. Court will stay the bond at $1,000 with respect to the failure to appear for driving with a suspended license, and Mr. Forbes will be held on the violation of probation, as that is no bond. Thank you.
This is yours.
Okay, thank you, ma'am.
You're welcome.
And she called me before. I seen her on Friday and I seen her before she got out of
Unfortunately,
All right, Nashali Pinheiro Benitez, we are here for a first appearance on a charge of violation of probation on an underlying charge of burglary of an unoccupied structure or conveyance. Court appoints the public defender to represent you. Finds, let's see.
bond, I think, was 0, Your Honor.
The bond set forth in the warrant is 0, so Ms. Pinheiro Benitez, you'll be held until you have further proceedings in the case before the court that puts you on probation, okay? Thank you. Bruce Cadogan?
Cadigan, sir.
Cadigan.
Yes,
I
sir.
should have known. First appearance on a claim of open container. Would you like for the court to appoint the public defender for you? No? Yes?
Yes, sir. Yes.
Yes, I'll appoint the public defender for you. Court finds probable cause for the charge alleged. What says the state?
Your Honor, if the defendant wanted to resolve his case today, the state's offer would be an adjudication of guilt, court costs, and any credit for time served. If the defendant does not wish to resolve his case today, the state would leave the matter in the court's discretion.
Your Honor, defense would like to plea to the bench for a withhold adjudication, court costs, credit time served.
All right, sir, do you understand, the consequences of pleading to the bench? It means that I'll get to determine the appropriate sentence to impose?
Yes, sir.
Okay. And you understand you're giving up your right in doing so to show your innocence at a trial later in this matter?
Yes, sir.
Okay. Based on the plea to the bench, court will withhold adjudication. How long has he served?
1 day.
Sentence you to 1 day with credit for time served and impose court costs payable within 360 days.
And be a plea of no contest.
Plea of no contest. Thank you, ma'am.
Oh, no, the immigration detainee.
All right. Thank you, sir. Paul Clark?
He's now helping on it.
Freddie Galloway?
Yes, sir.
All right, good afternoon, sir. You're here for a first appearance on a charge of open container. Court will appoint the public defender to represent you. Finds probable cause for the charge alleged. What says the state?
Your Honor, were the defendant to wish to resolve his plea, the state would offer an adjudication of guilt, court costs, credit for any time served in light of the fact that he's already been convicted of this before. If the defendant does not wish to resolve his case today, the state leaves the matter in the court's discretion.
Your Honor, defense would plea to the bench for a withhold, court costs, and credit time served. This is an open container charge.
All right, sir, you understand consequences of pleading to the bench and that the court will be able to determine the appropriate sentence?
Yes, Your Honor.
All right. I assume that's a plea of no contest, and on the plea of no contest, court will withhold adjudication. How long did he serve?
2 days.
Sentence Mr. Galloway to 2 days with credit for time served and impose court costs. Payable in 360 days.
Your Honor, he's asking for the PD to be appointed to his case, and he'd like to resolve this today.
Okay. Nicole McKelly?
Mental health, Your Honor.
Michael Medina?
Yes, sir.
All right, you are here on a first appearance related to a charge of open container. Court appoints the public defender to represent you in this matter and has found probable cause for the charges alleged. State have an offer?
Yes, Your Honor, withhold court costs and time served.
Your Honor, defense would accept that offer. He's entering a plea of no contest, and we're asking for 360 days to pay.
You understand the terms of the plea that's been, or the offer that's been made to you, sir?
Yes.
Okay, and that by entering into that plea agreement, that you are giving up your right to prove your innocence with respect to the charges?
Yes.
Okay, the court accepts the plea.
Yes, sir, to withhold adjudication, credit time served, and court costs. If there is no conviction,
That's court course rate of 300.
Yes.
that mean?
Your Honor, this is Arnold Lee Patterson. He also is requesting the public defender to be appointed to his case, and he'd like to resolve today.
All right, sir. Charge is open container. Court appoints the public defender, finds probable cause. Does the state have an offer for Mr. Patterson?
Yes, Your Honor, considering the prior in and out-of-state convictions of the defendant, the state would ask for an adjudication of guilt and court costs. The state is aware that the defendant, at least to my knowledge, has not been convicted of open container before.
Your Honor, this was Mr. Bruce Cadigan's co-defendant. It is an open container charge. We'd like to plead to the bench and ask for a withhold court cost with credit time served.
Withhold court costs?
Yes, and credit time served. It'd be a plea of no contest. It looks like the last Florida conviction was in 2010.
Why without court costs?
It was a withhold of adjudication, court cost, and credit time served. So still court costs, not a waiver.
She said
Sorry,
that.
I don't know if I misspoke. Sorry about
I
that.
think you did,
Okay,
but that's okay.
I
do it too.
apologize. Sorry.
All right, you understand that you're pleading to the bench and the court will determine the appropriate sentence?
Yes, sir.
Okay, and that you're giving up your right to prove your innocence in court?
Yes.
Okay, great. On the plea to the bench of no contest, the court will withhold adjudication. How many days was he in?
Just one.
One, sentence you to 1 day with credit for time served, and order court costs payable within 360 days.
Your Honor, if we may, I don't know how exactly to approach this, but in regards to State versus Michael Logan, that was the 911 abuse case earlier. Incidentally, I emailed the officer listed in the affidavit, and she's actually already responded to me with the name of the operator. I don't know if that can be added to the court minutes, or if I should just provide that to defense counsel so that she can forward it to me as well as to the law enforcement officer.
Well, I think what was contemplated was he's going to file it, right?
I believe that the current order is essentially that the defendant will file the letter of apology with the clerk of court. It will be served on the state, and then the state from there will try to figure out the name of the operator. The reason why I'm interested in perhaps more directly resolving the situation, whether that's through the clerk or whether that's just through me providing my information to counsel, is just the fact that the state was not assigned to an ASA, so there would be no one to reach out to at the state attorney's office to figure out who that person was.
Right, let's just put it in the minutes then. All right.